All at the same time?
Yes. So in case you guys forget. I don't think anyone's talking from here. I don't know. If you're gonna any intro people should be from here, so they pick up on the mic.
Okay. You work this week? Yeah. That was totally great. Busy week. Yeah. It's wonderful. Thank you for organizing.
I wanted to say hello. We met at the Justice O'Connor tribute.
So great to see you. Yes, how are you? Thanks for coming. Check 1 2. Check 1 2.
I guess you're not.
Check. Lavalier mic. Check. Check. Okay.
Katie, I don't think we've ever actually.
Nice to meet you.
So you wanted a lavalier?
Oh, yeah.
You don't want to stand here, is that what it is?
You think is it easier just to center? I'm just.
Well, I just checked that it works, so.
Your mom?
it.
Okay.
Well, if you want your tie or your jacket.
I know I should have.
Jacket is great, people. I had Senator Ron Paul. Not to buy, but just trust me, it's on. You clip it on your belt.
Great.
And they're starting in 5 minutes.
And can I turn it off, or is it on?
Well, we're starting in. Now you want to talk a little bit?
I want it to be. Very positive. No, are they?
Very well. How are you?
Isn't it ridiculous the number of CFTV things that are around? You know, we have kind of a
Yeah, I think I probably am
because,
that sentence of ridiculous.
we're the we represent FHFA.
I want to hear that story.
Yes,
And so we're sort of,
Not as good as if I
you know, watching this from the margins and, you know, wondering if SG would let us.
we just have 7 between us.
They never do anything if FHFA combined with our own quarter bureaucracy to make the perfect storm of delay and memo writing. So,
Suffice it to say, we're filing something.
yeah, I figured.
Probably during this panel.
But isn't it
I'm
crazy? I mean, it's like everybody is rushing out to try to get on this train.
And shooting at us, and it's really.
Possible to like actually say. Congratulations, by the way. Thank you. No, it's really fun. It's great. And it's
It's really helpful.
Yeah.
Wow.
And it's just great because it's part time. So
But it's really,
I have my time on really interesting things. Have time.
you know, in the
So how many kids do you have?
petition and
2 and on the way.
congratulations.
And how old? So I remember when.
Sort of thing.
Yeah.
Were you guys the same
Read it in the lower
I work for no.
and so it just is what it is.
I didn't think it was a very good.
I know for my boss.
Anytime you have a page-long footnote, you might as well just break down.
Right at the beginning of the petition. Well, that petition actually I'm going to use as an example because it has
Yeah.
and you know, I'm sort of a big believer in the proposition that
Kara.
Oh,
Nice to meet you.
Nice to meet you.
Hi.
Conquer the perfect
Put
identity.
faces to. After all that, I know.
I got a brief from one of my partners this morning. Exactly the same.
I just want to make sure we're not blocking the Can you move them out to the opening? Is that okay?
So what do you think our chances are?
The ACA case or whatever for so long.
We're far enough away from here.
No, but it's just such a topic.
Did you have to deal with, I guess, recusal issues? Did that come up after stuff that you worked on at OLC? And coming up? No, for coming up now as a justice. Was there anything, or was there like not?
There's really nothing.
Not that. I think it's like state. Yeah.
You guys are so much more interesting than me. I'm just going to sit back here and put my one little idea out there. And then...
Two and more. How about yours?
7 and 3.
Oh wow.
Do you
You're
live here?
slowly. You're slowly like on the.
Yeah, so
Tell me, maybe.
no, absolutely, absolutely. The 7-year-old is easy now. When he was, your kid's age, it was like this mayhem. It was great. So that's
Good to hear.
Maybe that's by comparison to your 3.5.
Yeah, the comparison definitely helps him. But it's a lot of fun.
Do you live in DC?
I live in Boston. So I can do most of my work out of a skip there, and then I come out about once a month.
It's really interesting. I mean, today that must be you must have a lot on your plate for you.
It is, although people keep asking me about Ukraine. I'm like, we don't do that.
You're not doing Ukraine.
It's not on the call.
Okay.
But it is.
So what?
Oh, yeah. Yeah, you're going to ask about that. Here we go. Ladies and gentlemen, welcome to our symposium celebrating the 100th anniversary of the Supreme Court clerkships. 100 years ago today, not today, but 100 years ago this year, Congress passed a statute authorizing each justice to have a stenographer and a clerk. And ever since then, the clerkships have developed into a superb institution, and the National Constitution Center in Philadelphia is honored to bring together former Supreme Court clerks for the first time in history for an all-clerk reunion, representing clerks from 25 justices over 50 terms to come and celebrate this great anniversary. I am Jeffrey Rosen. I am the president of the National Constitution Center in Philadelphia and also a professor here at George Washington Law School. And I'm so happy that both of these institutions I care so much about have united for this important academic symposium. The Constitution Center in Philadelphia has a very inspiring mission from the US Congress, and that is to bring together citizens of different perspectives to educate themselves and celebrate this great document of human freedom which binds us, the US Constitution. And we do that by assembling panels and podcasts, and most importantly, educational materials that bring together leading thinkers in America from all perspectives to explore areas of agreement and disagreement about the Constitution. The most exciting platform for our educational efforts is called the Online Interactive Constitution. It is a remarkable platform where the Federalist Society and the American Constitution Society have nominated scholars to write about every clause of the Constitution, describing what they agree about and what they disagree about. And it's thrilling that this amazing platform, which has gotten 25 million hits since it launched in 2015, has 30 former Supreme Court clerks among the more than 125 contributors, and you'll be hearing from some of them this evening. This morning, GW Law School brought together clerks associated with GW, both former students and current faculty. And one of the clerks talked so powerfully about how her clerkship taught her how the justices and clerks can disagree without being disagreeable, can have substantive debates about important constitutional matters without descending into partisanship. And that's what the clerkships model, and that's why it's so inspiring that our panels today bring together justices, clerks from different justices of different views and different years to share their experiences and to respectfully engage in civil dialogue, which is the essence of the American experience. So we have 3 panels. The first is about people's experience during the clerkship. The second is about life after the clerkship. And the third is a really wonderful opportunity to hear from two of America's greatest judges, Judge Diane Wood and Judge Jeffrey Sutton, about how their experience clerking on the court influenced the way they interpret the Constitution and the way they approach their role as judges. And we have a remarkable first panel, and it's going to be very ably moderated by Canon Shanmugam, and he is chair of the Supreme Court and Appellate Practice Group at Paul Weiss, and he clerked for Justice Scalia, and he is going to introduce the panel. Canon, take it away.
Great. Well, thank you very much, Jeff, and it's a great pleasure to be here at GW Law School, just a couple blocks away from my office, so I always think of this as very much the local law school. But it is a great pleasure to be here. Thank you to GW for hosting us, and thank you to the National Constitution Center for putting together this program. It's really my great privilege to be the moderator of this first of the afternoon's panel, and we have an incredibly distinguished group assembled here to talk about the wonderfully broad subject of clerkship experiences. And so very briefly to introduce the panel, starting on my immediate left, John Elwood, who is a partner and the head of the Supreme Court and Appellate Practice at Arnold and Porter, and John clerked for Justice Kennedy. Justice Leandra Kruger, to his left, a member of the California Supreme Court, who clerked for Justice Stevens. Rory Little, a professor at the UC Hastings College of Law, who is currently visiting at Yale Law School, who was originally hired by Justice Stewart and then basically clerked for the entire Supreme Court, and we'll talk about that in due time. And then finally, Jane Nitze, who is a member of the Privacy and Civil Liberties Oversight Board. She merely clerked for two justices, Justice Sotomayor and then Justice Gorsuch, for whom she also clerked on the Court of Appeals for the 10th Circuit. And so I thought we would start today at the beginning and talk a little bit about the experience of interviewing for a Supreme Court clerkship and getting hired for a Supreme Court clerkship. So I think I'll start at the far end with Jane, who is our most recent Supreme Court clerk and therefore presumably has the best memories of getting hired. Obviously, getting hired by Justice Gorsuch was a little bit unusual since you worked for him on the Court of Appeals, but maybe you could tell us a little bit about getting hired for your first Supreme Court clerkship by Justice Sotomayor.
Yeah, sure. Yeah, the second time around it was a phone call. Which was a lot easier, no interview. So the first time around, it was, many people applied to the clerkship already out of their circuit clerkship, but I was so aware of doing so. I didn't think I quite had the background, the grades, et cetera. And so I went on to a law firm. And it was a law firm that I think then Judge Gorsuch called me once a week. And he was like, get your application into the court. And so I recall sort of collecting the materials, and it's standard stuff, resume, writing samples and the like, and you send it to all justices across the board. And then I just remember being sort of stunned the day that I got a phone call to come in and interview with Justice Sotomayor for, I think, a few days, from the phone call, so there really wasn't that much time to prepare. And, it's very intimidating. You walk into the court, and it's this grand building, of course. And I think most justices have interviewees interview both with the clerks and also with the justice. And each justice, I think, has different preferences on how substantive the interview will be. Justice Sotomayor, I think, this is publicly no knowledge, is sort of fairly substantive. And so we had to sit down with the clerks and then with the justice. And one thing that just struck me about her is that there was certainly a substantive component to the interview, but there was also a very personal component to the interview. And what she talks about is that she really cares deeply that the clerks are civil with each other, are good people, will get along with each other, will get along with clerks from all the other chambers. And I think she sort of tries to screen for that in her interviews. And so that was that. And I got a call sort of a week later and was obviously thrilled to say yes. And it was an amazing year from there.
So I'll turn next to Rory Little. So Rory, you really did, in a real sense, clerk for, I think, 5 justices, which has to be like the modern record. So tell us a story first about how you got hired by Justice Stewart, and then about how you came to be the serial law clerk.
Well, thanks, Ken, and thanks to Jeff Rosen and GW. How many law students do we have in the crowd? Raise your hands, be proud. If you're still looking for a job, these other folks... So I got there through the back door in the sense that I applied twice to the Supreme Court, 2 different years, and was rejected by all 9 justices 2 years running. I had a visiting professor at Yale who was disenchanted with Yale, who wrote a letter for me. And when he wrote the letter for me, he said to me, "Oh, by the way, I'll write for you, but you just got to remember being selected is like being struck by lightning." And I think he was trying to let me down easy, like, you're just not going to be in that group. But Justice Stewart, it was not as well known that the retired justices had clerks at the time. A friend of mine clerking for Justice Blackmun actually called me and said, "Blackmun just picked, you're done. You didn't get picked. But have you thought about the retired justice?" And I said, "No, I hadn't." So I sent a letter in to Justice Stewart. And what I didn't know, I had interviewed with Powell, and Powell had sent a note to Stewart saying, if I could have hired a 5th clerk, I would hire this guy. So I got that job through interviewing really with Powell. And I just wanted to say that you can't prepare for these interviews. I thought there would be a substantive component to the interview, and Justice Powell really wanted to talk about nothing other than who I was, where I'd grown up, what my parents had done, what their parents had done. It was very personal, and I wasn't prepared for that. But then when I got there, I'll just say, Justice Stewart very kindly sent a note around saying, "This guy's available because I only have sort of half-time work," at which point Chief Justice Berger let me do cert pool memos for him. I arranged 2 months with Powell, 2 months with Stevens, and 2 months with O'Connor. And then Brennan picked me up as a full-time clerk because he had an open spot unexpectedly. So suddenly I was working for him full-time. And then at the end of my 2 months with Stevens, he said, "Would you please stay with me full-time?" Because he only had 2 clerks. Everyone else had 4. And so I went to Brennan and Stevens and I said, "I'm going to be working for these other," and they both said, "It doesn't matter to us. We want them to know exactly what we think. There's no confidentiality here. Just tell them." And so that's what I did. And 2 months with Powell. The only person I didn't work for was Justice O'Connor. She was new, and when she learned that I was going to be full-time in Brennan's chambers and Stevens' chambers, she said, "I'm going to pull out of my 2 months with you," because she was worried about confidentiality. And she later said to me, "I was new then." She said, "It shows you how long it's been." Anyway, it was great.
Yeah, you've been able to hold down a job a lot better since then. So I have a question for Justice Krieger, which is a 2-part question. It's great being an advocate and being able to ask a judge a multi-part question. So my 2-part question is this. First, tell us about your interview with Justice Stevens, and as a sitting justice on this panel, tell us a little bit about how you interview law clerk candidates.
Sure. Well, I was a little afraid you'd ask this question because I remember everything about the day I interviewed for my clerkship in extraordinary detail. I remember getting off the metro, walking out in front of the Library of Congress, on my walking up the Supreme Court steps into the marshal's office to wait to be picked up for the interview. I remember virtually nothing about the interview itself. It's as though I had an out-of-body experience. I think I spent the whole time sitting across the desk thinking, oh my goodness, I am talking to John Paul Stevens. I do remember one question that he asked, which was, what Supreme Court's decision did I think was the worst? And I had a moment of ever or recently, but the remainder of the conversation apparently went fine.
So what was the answer? Or have you blanked that out too?
I may have blanked that out as well. I think I named a recent decision that, unsurprisingly, he had dissented from.
Okay, all right. That's a diplomatic way of putting it. So tell us a little bit about how you interview for candidates.
Well, so I try to get a sense of why they're interested in the job, what interests them in clerking on a court of last resort, as mine is in particular, because the role that we play in our system of appellate review in California is different from the roles that other courts play, including intermediate courts of appeal. And so I like to get a sense of sort of what is the candidate's interest in working on those issues, and what is the candidate's interest in the law generally, sort of where does this fit into that person's set of thoughts about the range of things that might be of interest to them after the clerkship experience. But I think one thing that I really learned from working with Justice Stevens, and especially from returning to visit with his law clerk family over the years, is the importance of not only competence in a law clerk, but also character. I think one of the things that really strikes me about the way that Justice Stevens selected clerks was that he was really interested in finding people who were not only very good at learning the law and doing the research, but were also nice people, good people to be around, people who were inclined to lend a helping hand to people around them. And that is something that I try to look for as well when I do my clerkship hiring.
Just a point of clarification, you're not completely a court of last resort. I'm about to file a cert petition from one of your decisions. So just to be clear, you didn't write the opinion.
We'll see what happens. She may end up being the court of
the odds are mathematically in her court's favor. John, tell us a little bit about your experience being hired by Justice Kennedy.
Well, Justice Kennedy, it's a very complicated, or it was a very complicated process. He had kind of two rounds. You first had the screening interview with former clerks, and then you would go into the justices' chambers. And both the screening interview and the interviews with the clerks tended to be substantive. And so you literally prepared for it like you would an exam. I mean, you just read a stack of Justice Kennedy's opinions so you can get a sense of his work. And answer questions about it. But it came at a good time because I was given the screening interview right after the blizzard of '96. So I was literally trapped at my crummy apartment in Crystal City, and I had nothing to do but read the opinions anyway. So that was kind of fortunate. But the interview with Justice Kennedy himself was much more at that point. If you've gotten to him. He's decided, his people have all this, talked to you, and he's decided that you have the stuff. And the question is what kind of a colleague you'd be. So I pulled the wool over his eyes. But I still remember how he began it, but that's about the only thing I remember is he said, "So how am I doing?" And, it's kind of an open-ended question, and it's, potentially fraught. I don't remember what my answer was, but I apparently didn't offend him. But it was, he was, incredibly, gregarious and a pleasant person to talk to. But,
can I tell you that was not a question Justice Scalia asked me during my interview? That may reflect some personality differences.
Yes, I suspect so.
Between the two of them.
Are you going to tell us about your interview with Justice Scalia?
No, I'm going to exercise the moderator's prerogative. So let me throw though I will say that my recollection is a lot like Justice Kruger's. I remember everything but the actual interview. Let me throw a little bit of a fastball at the panel, and it is this. One of the criticisms of the Supreme Court clerkship is that it's a very elite, clubby institution, and this panel consists of 5 people. I think 2 of whom went to Harvard Law School, and 3 of whom went to the other well-known law school. And those 2 law schools, Harvard and Yale, provide a vastly disproportionate number of the Supreme Court law clerks. The justices tend to hire their law clerks disproportionately from the same small number of Court of Appeals judges, many of whom are their friends. And so what do you say to the criticism that this is not a terribly meritocratic institution, it's something of an elitist one? Nobody wants to answer that question.
So I have tenure, and I'm not going to get nominated for anything. So I'll say, of course it is not a meritocracy entirely. It is a set of connections. It's horribly that way, in my opinion, which doesn't mean you can't break out of that. And some of the justices now, I think, are working hard to hire from a diversity of law schools in some sense. And some of it, I think, has to do with the belief, which may or may not be true, that these law schools do produce really good lawyers, and that they, today at least, screen through other judges.
That's half true.
We'll see which way that works.
Nobody got my chip.
So, I think we all probably could tell in candid moments, if we weren't thinking of our futures, stories of connections that were developed at these schools.
I guess the one thing that I would add is, I think I'm somebody who went to law school not really knowing what it meant to be a lawyer, not really knowing a lot of lawyers, very up close and personal. I think I went to Yale Law School, where there was a very substantial culture of clerkships. There was a focus on the importance of clerkships and the value of having that clerkship experience that I might not have gotten quite as much of if I had gone to a different school. And I think that was certainly part of what opened my mind to the possibility of clerking after law school, and part of what ultimately led me to throw those applications into the mail, where I might not have done that if I hadn't gotten the same degree of encouragement. I think when I was in law school, there was a sort of part of this culture of clerkships was also a lot of anxiety among the students about creating the connections, developing the relationships with the professors who knew the judges and so on. And I found that dynamic pretty off-putting and difficult to navigate, and so sort of tried to bypass it as much as I could. Part of what ultimately led me to apply for the clerkship, and part of what I think ultimately helped, was the set of relationships that I developed after law school when I had started working and had actual day-to-day working relationships with practicing lawyers who both provided the kind of kick in the pants that Janie was describing to get the applications in, and provided also the support necessary to the willingness to sort of vouch for me and for my abilities and for my potential as a lawyer, that I think ultimately laid the groundwork for my being able to get the job.
Any other thoughts on this subject? John, Janie?
I think that there's a much broader pool of people who could do the work than who are selected, because what your professor told you about lightning striking is right. It's or winning a lottery, and that there's a fair number of people who could do this work, and so it really kind of just depends on winning the lottery once you're there. I came from Yale, so I had at least, I was one of the schools that produces a lot of the clerks, but I at least did come through a judge who, I was his only Supreme Court clerk ever. He was not one of the feeder folks. But I do understand somewhat why justices go back to the same clerks from the same judges so often, just because, certain things are so important. And having the recommendation of somebody who you trust and who has, given you reliable advice in the past can be very helpful. And I understand, when you see some of the cases that they take that are so hard, you can see that they want, they don't want to leave anything to chance.
Yeah, I don't have all that much to add to it. It certainly felt like lightning struck, and I think it is lightning striking. There are certainly more qualified folks out there who can do it than people who get the job. The only thing I would add is something that you touched on, which is I do think it is getting better. I think the justices are making a concerted effort to look at schools beyond sort of the top 5 or the like. I know that Justice Gorsuch, for instance, he has a screening committee. I'm on it, and we try very actively to look at schools beyond sort of Harvard, Yale, and the others you might think of. And once you're sort of picked out of the pile, then from then on, I would really say it is substantive, and personality, of course, and fit. And then the only other thing I would add is I do think it helps. I also felt it was off-putting in sort of law school to try to actively for the purpose of getting a clerkship make connections with professors or the like. And so I didn't do the nice sort of squeeze through just because I lucked out in having, as a circuit court judge, someone who was a phenomenal mentor for all of his clerks, and so really pushed us to achieve what he believed we could achieve. So I do think it is important, nevertheless, to have sort of someone behind you and some mentor behind you, pushing you to take those steps, and also being willing to sometimes make a phone call, because those phone calls do matter. I don't know that makes it elitist, because the phone calls are in my experience, based on merit. It's a judge or professor saying, listen, this is really the best of the crew that I've had in the last 10 years. You should really take a close look. It doesn't mean that person's going to be hired, but it means that folks will take a look at him. And so that is one sort of piece of advice I would have.
Can I add one
Yeah,
more
of
thought?
course.
This is for the students who are here from GW. There is no easy, direct path to this. And my really strong advice is follow your heart in some sense and not some preordained path that you think works. And I'll tell you two things. One, I turned down a circuit clerkship, which I had been sent to by a screening panel at Yale in favor of a district court judge. And when I got back, the professors who had sent me up to the circuit judge said, why'd you pick this obscure district court judge as opposed to this guy who's a feeder? And I said, well, this guy was a jerk to me, frankly, in the interview, and I like this district court judge. I didn't have any pretension of going to the Supreme Court. 2 years later, when I finally got there, Justice O'Connor had also picked another clerk from the same district court judge, Judge Oberdorfer, here in the district, at which point the National Law Journal had a headline that said, Oberdorfer feeder to the Supreme Court. The other thing I'll say is I didn't have a letter from the prominent professor. I had to use a visiting professor who didn't like Yale that much, and so we would run together. We would run together 3 days a week. And that's why he was willing to write me a letter. And it turned out he had clerked for Justice Powell, and Justice Powell interviewed me, and this is what. So don't go after, don't get stuck in that. Leandra's exactly right, that you don't get stuck in that sort of, I got to do the right thing in order to position myself for something 5 years from now. It doesn't work that way.
Great. Well, our panel is captioned clerkship experiences, so we should probably talk about the clerkship experience. Maybe I'll start with John. We'll go in the other direction this time. Just give us a sense of what it was like to clerk for your particular justice, what you did, and what the day-to-day life of being a Supreme Court clerk was like.
So I had the office closest to Justice Kennedy, which meant that he used me as essentially the administrative person too. And he used me for all sorts of default things. Like once I got a call from him when he was out on the road, and he was in, I think, Asheville, and he said, John, I need a good barbecue place. So I would, and this was before the internet, so I actually had to go on to Westlaw or Lexus and look for restaurant reviews. But I found him a place, and it was conveniently located next to the hospital in Asheville. But, it was, there's the opinion work, of course, and getting them ready for the argument. So there's merits work, there's cert work, and then there's kind of the emergency stuff like death penalty, things like that. And then the bullet that I dodged, speeches. I never had to write a speech for him, and I feel like karma is going to bite me at some point for that favor. But whatever happens to me, whatever grievous disease I die of, it will have been worth it because at least I didn't have to do the speech. But the cert work is kind of constant throughput, and you got to do that every week and stay on top of that. The merits work is the kind of glamorous stuff. But
we should be clear, by cert work, you mean the review of petitions for certiorari, petitions for review to the court.
Right, exactly. But I think that the thing that's most noteworthy is that Justice Kennedy wanted to talk about all of his cases with all of his clerks, and so we'd sit around the table and you'd have an opportunity to chime in and talk about it, and he would take it very seriously, and we'd just talk about it endlessly. There are cases now that are just so obscure, like admiralty cases and things like that, and we would just talk about them for hours on end, sitting around a table. And I thought about the Three Stooges joke where you paint eyes on your eyelids so you could fall asleep, and you just think you were staring at them. But he took them all very seriously, and one thing he was always very fond of was he had a big pad, and he would find a way to do a diagram for almost any case, even if you didn't think it was particularly, because we'd use the diagram even for the admiralty case, so I don't quite understand that. But that was one of the good things, is you had an opportunity to chime in on every case, although it was also a curse.
So Justice Stevens was famous for doing a lot of his own drafting, and so did that make the clerkship experience a little bit different with Justice Stevens?
It made it a little bit different. It didn't make it as different as I think I had expected it to be before I started the clerkship. It was often, so Justice Stevens sort of famously would always write his own first drafts for the purpose of assuring himself that he had cast the correct vote in the case. Once after the opinions had been assigned, he wanted to make sure that his reasoning held up. And so for him, writing down his reasons for a particular vote had a sort of disciplining function, making sure that everything held together. At the very beginning of the year, sometimes those drafts would come in and they would be fairly complete. There'd be some fleshing out to do, some additional research, addition of citations. But we quickly learned that that wasn't always the norm. He would write sort of just enough to perform that function of making sure he cast the right vote, but not more. So sometimes we would be sitting around the table talking about a case after conference when he was reporting what the vote had been and what the likely outcome was. And he would go back to his office, and about half an hour later, an email would pop up in my inbox with, sort of 2 paragraphs of just sort of the seeds of a separate opinion. And it was my job to sort of take that reasoning and sort of flesh it out and make it into a sort of fuller-fledged opinion. And the sort of the exchange of ideas through the opinion writing process was really, really remarkable in a lot of ways. Justice Stevens was, at the time I clerked for him, he had been on the court already for almost 30 years, which was longer than I had been alive at that point, and just brought to every case, sort of both a wealth of background knowledge and sort of inside baseball about the set of precedents that had led us to this point, but also just a real enthusiasm for learning more. He treated every case as an opportunity to learn something new about a new area of law or life that he might not have known very much about before. And it was, in the end, in addition to being an incredible educational experience, it was just a lot of fun.
So, Rory, as we've discussed, you're sort of in the unique position of being able to compare and contrast clerkship experiences across multiple chambers. So tell us a little bit about how the practices of the various justices for whom you clerked differed.
Well, I'll do that, and I'm going to share an idea with the clerks in the audience. But here's what I'll say first, which is one of the huge values of this experience is not as much your relationship with the justice as with your co-clerks. And when I say co-clerks, I don't just mean in your chambers. I mean the clerks in the building, the 36, 34, 37, whatever many. Those folks are still some of my closest friends, and most of us, I think, are having a reunion this weekend of just our terms clerks across the chambers. And so that's a huge thing to think about. And I'll say this as well, there's a basketball court in the court. Did you ever play in the court?
Not very well.
No, none of them. Nobody plays very well, but that's why we're all law clerks. But it's important to do that because the collegiality among the chambers, I think, was very important to the way the term went. My term, October term 84, produced, a few decisions, no earth-shattering ones that you might remember, but the clerks all got along very well. That's not true every term. And the idea I want to put out there is I don't know why justices don't share law clerks across chambers. I'm going to publish this in the GW Law Review, I hope, as a result of this panel, the idea of sharing law clerks across chambers. Lots of courts do this. Lots of courts share law clerks. They have staff attorneys. Those attorneys work for lots of the judges, and it lends to collegiality, a better exchange of ideas, and better work product, I say. What was different? I'll tell you 2 stories. First, Justice Stevens did exactly as you said. He would sort of go into his chambers or his office and produce a writing. Justice Brennan never did anything on paper. We would just sit for hours. It was called Coffee with Brennan. You go in at 8:30 in the morning, and Coffee with Brennan could last until 1:30 in the afternoon. And every time you sat down to write something, you had talked it through with him so much that you're just holding the pen. And once I was working on a opinion for Justice Stevens, but I was sitting at Coffee with Brennan. He was writing the other side of that case, and it came up, and I said, Justice Brennan, I should leave the room because I'm working on the other side for Justice Stevens. And he said, no, sit down. I want John to know exactly what I think. you know, this was valuable. This also shows the confidence of a justice who's been there a long time. On the other hand, Justice Stevens once handed me an opinion, you know, a draft, and it was not a, it was an obscure case. And he handed it to me and he said, I think this is pretty good, but you could work on the footnotes, which I thought was a pretty clear signal. So they were different, but I don't think they were different in how they treated their clerks. I don't know anybody who clerked for Brennan or Stevens who has anything but good things to say. You'll hear from Judge Wood later, but Justice Blackmun was the opposite. Everything was done on paper. And the poor Blackmun clerks would produce these 35-page bench memos, and the Brennan clerks would just sit around and have coffee. And maybe that was reflective of work product. I don't know. Anyway.
So Jane, you clerked for two justices who I think it is fair to say have somewhat different jurisprudential views. Talk a little bit about sort of what it's like as a law clerk when you are clerking for a justice and you might have a different reaction to a particular case, say.
Sure. I get this question a lot.
I imagine you probably do.
But I actually think the experiences to me were more similar than dissimilar, and my job was pretty much the same, and the justices were interested in pretty much the same thing. So for each case, they wanted a bench memo. Justice Sotomayor wanted a fairly lengthy bench memo. Justice Gorsuch is more on the sort of let's talk it through. So he wanted a short memo, and then we had an extremely long discussion about it with all the clerks gathered in the room where everyone was sort of piping in. But they just were both interested in what does the law say. You know, one was maybe more interested in what does the legislative history say, one less so, but that's a little bit in the details. And so the process of doing the bench memos, talking with the justices, creating the opinions, it looked very similar. I would say that in terms of, you know, how would I feel if I differed with a justice, which happened with both justices? You know, I think I would say something that Justice Gorsuch always told me that Justice White told him when he clerked for him, which is, you know, no one appointed me and I wasn't confirmed by the Senate. So at the end of the day, it was not my job to push my either jurisprudential view or my view of the case. And I recall in particular one case with a justice where I disagreed quite strongly, and we talked about it for really weeks on end. And at the end of the day, the justice said, thank you very much. I appreciate your views. I think I've made my decision, and we just disagree. And then I went around to every chambers and tried my best to get other chambers to agree to that justice's view, because that was my job. And so it didn't make it difficult for me to work with two justices from, you know, so-called sort of what some might perceive as different ends of the spectrum. And the other thing I would say is I think that the differences between the justices are often exaggerated in the media and justices generally. And, you know, we shouldn't forget that I think it's now 40% of cases are decided unanimously. These are, you know, the hardest cases in our entire judicial system. 9 justices, I mean, I can't basically agree on like coffee with like my 4 board members, you know. So 9 justices are coming together unanimously in 40% of the cases, and that figure has remained, I think, essentially consistent for the last 100 years. The number of 5-4 cases, I think this past term was maybe 18, but most of those 5-4 were not the 5-4 we think of. I think the 5-4 that folks think of it's just a handful. And so I think the differences are often exaggerated, and the similarities should be looked at as well. And personality-wise, and one thing Roy was saying about his justices, both Justice Gorsuch and Justice Sotomayor treat their clerks the same. They both call them their clerk family. Justice Sotomayor routinely officiates weddings. She did my wedding. Justice Gorsuch has folks over, you know, they'll sleep at his house when they're there overnight. They come to Christmas, Thanksgiving, if they are not flying home to see their families. And so they're both just fundamentally very good people and treat their clerks well, and they get along great too.
Let me ask a little bit about the role of the law clerk, because I think there has been a lot of writing, with some criticizing the law clerk system for giving law clerks disproportionate power and responsibility. After spending a year or more than a year at the court, what is your reaction to that? And anyone can weigh in on this.
Well, my view may be a little bit colored by who I worked for, but I don't think we were ever under any illusions at any point during the year about the extent of our power, and it was not great. There was really, sort of no doubt that Justice Stevens, who was such an independent thinker in so many ways, was going to make up his own mind and make his own decisions. And as I said, he was already a very experienced judge by the time I clerked for him. I think part of the value of the clerkship from his perspective was really just, I think we tend to forget when we're in the outside world that really conversations about these very difficult cases are confined to a very small number of people. A judge can really only talk about these difficult issues with the set of people who work in their chambers. And so for Justice Stevens, as I think as for his colleagues, the clerks fulfilled this role of sort of being a sounding board for just sort of thinking through these difficult issues, for sort of running down the loose threads in the doctrine as it has developed over time. But I don't think there's really any doubt that at the end of the day, the decisions belonged to the justices and the justices alone.
Let me just pull the veil away a little bit. I don't disagree with anything you just said, but I think the reality is that law clerks have a very large impact on what I would call the footnotes, the details. You're not changing decisions so much as you are, and this is part of my sharing of law clerks idea. I can think of instances where I went running or whatever, had a cup of coffee with a justice's clerk from another chambers that was opposed to the position of my justice and said, well, what about this one thing you said in a footnote? Couldn't you just change that one thing? And maybe they would. Maybe they would say, yeah, we don't need that, or you're right, it has a harsh effect or something. Law clerks have an impact on the details, and the details often come back to haunt us later when we're reading the decisions or trying to apply them. And it seems to me, in Brennan's chambers, nothing got out of the chambers until all four clerks had worked it over. Even if you were the primary clerk, everybody worked it over. My experience with Justice Stevens is it really was more of a one-on-one dialogue. And of course, he was a really smart lawyer. It seemed to me the wider the discussion was, the wider the range was, the better the work product was. So I'm just going to throw that idea out there that law clerks matter, and collegiality among the law clerks matters.
And what about the fact that a lot of the communication that takes place within the court takes place between law clerks? I mean, not always. Right. Justice O'Connor really preferred for her law clerks not to talk to other law clerks, at least about her views. So there were, I think a wide range of views among the justices about that. But there's no doubt that a lot of the decision-making process kind of flows indirectly through the law clerks. Is that a good thing?
I never got the perception that the fact that so much communication happened between the law clerks, which as a parenthetical surprised me when I came there. I don't think that gave power to the law clerks to affect the outcome of the cases one way or the other. What I was going to say is actually one of the areas where I think maybe law clerks have disproportionate power is in deciding what cases the court takes, just because of the sheer volume of cert petitions that are filed. You have two processes. You have the cert pool that I think NAGA 7 of the 9 justices participate in, and then you have 2 of the justices that had their chambers review all of the cert petitions that come in. So in the cert pool, there were occasions when I recall coming upon a memo that would have been written by someone that it was pretty, short and totally in good faith short. But it really took sort of me going and pulling the original papers to then bring it to the justice and have it sort of filter out. So that's the cert pool, and then in the chambers that don't participate in the cert pool, I think the justices rely on the clerks to really flag the certiorari petitions that the justice should look at. And so that is one area where I think there is some discussion around sort of whether or not clerks have disproportionate power.
I think there's a study recently by David Strauss, maybe, about that, and just the associating the decline in the court's grant rate in part by the fact that law clerks recommend deny in virtually every case. And I think that I agree that it's really at the cert pool where the clerks have their most influence. As far as the opinions go, Justice Kennedy really marked up things very heavily. And the only thing I can say for sure is out of an entire term, and I drafted 2 opinions for him, I only know of one word that I really think that's because of me. That's because I took 3 semesters of college math. That one word is in the U.S. reports, and I won't even tell you what it is, but it is math related. But that's one thing is even though there's a popular impression, or there was a popular impression that Justice Kennedy had no backbone and he was, putty in the hands of his law clerks, that is not at all the experience I had. He would take, he would do things with opinions that, all 4 of his clerks would be saying, don't do that, don't organize it that way, and it went out organized that way. So it was definitely his work product. And I will say this, about law clerks affecting the footnotes. Justice Kennedy never used footnotes. He gave up after a certain point. There'd periodically be a footnote-sized addendum to the opinion, but there were never footnotes.
So it's funny you say that your contribution was one word, because I wrote an entire tribute to Justice Scalia, the gist of which was that my contribution as a law clerk was a single word and a single opinion. So, and I won't get into that either. We have about 10 minutes left. So let me raise one other big topic, and I don't want to trespass the jurisdiction of the next panel, or else Jeff's going to come down on me. The next panel is on life after clerking. I want to ask a question about the Supreme Court clerkship more generally, which is, do we attach too much importance to the Supreme Court clerkship? Does it have disproportionate cachet in our profession? The arguments in favor of that would be that the last 3 Supreme Court justices to join the court were themselves Supreme Court law clerks. That's a relatively new trend. An ever larger number of the judges appointed to lower courts are former Supreme Court clerks. The bonus for Supreme Court clerks at most major law firms is now $400,000, which is several times larger than for arguably equally qualified folks who clerk on courts of appeals. And it is very sadly many, many times larger than the bonus that I got as a law clerk. Coming off the experience 20 years ago. So, it's 1 year in a lawyer's career. Do we attach too much significance to it?
Yes. There were no bonuses when I was there, by the way.
You could have collected like $2 million. You could have gotten 1 bonus for each of your many clerkships.
I missed my chance. So, yes. Do I think that Supreme Court clerks are untalented? No. And I think that hiring somebody who's clerked at the court does give you a certain insider perspective, and likely somebody who's a very talented lawyer. So, but there's certainly a ton of people who are amazingly talented at whatever they're doing who didn't clerk there. I won't name names, but I do know one professor at Yale who never got a clerkship. And I think his incredible influential scholarship is a result of him feeling, I'm going to prove to them that I should have. And he's probably one of the most influential scholars in the United States today on certain subjects. So I say yes, but does that mean law firms shouldn't try to hire Supreme? No, it's understandable why they do. I don't much like the selling of clerks to clients. You should hire us because here's a clerk for Justice X. Without, I'm of counsel at a big law firm and occasionally have been trotted out as part of a team just to sell to the client, and that makes me uncomfortable personally. Anybody else?
I agree. This is kind of corollary to my point previously that there are a lot of people who could do this job. I don't think I know Supreme Court clerks who are not very good lawyers and who are not very good writers, too, for that matter. And I know plenty of people who were never Supreme Court clerks who are, vastly more talented. So I think it's a very inexact fit. But on the whole, they're a tremendously talented lot. And, I think the odds are pretty good that they're a candidate, and I think this is why they command such a premium, is because there's already been a very difficult screening process to get them to that point. And some of them are incredible. We hired 2 Supreme Court clerks this year, and like one of them, I was so impressed because she got through this grade prize at Harvard in like 8 classes. I thought, boy, that's pretty good. And then the next one had 15, and I thought, boy, they're both a lot smarter than me. And one thing I think is kind of funny, there is a person, another clerk for Justice Kennedy, who likes to joke that the 2 people who Justice Kennedy hired with the worst grades were me and Brett Kavanaugh. So it's good company.
And one thing that has been really noticeable, and Jane, maybe this is a question for you, is that it seems as if more and more people are now doing the Supreme Court clerkship a little bit later in their careers. It used to be that you would graduate from law school, do a first clerkship, and then go immediately to the Supreme Court, and now that's almost unheard of. So, does that reflect anything about the clerkship, the changing nature of the clerkship?
From my personal experience with my 2 justices, it was their preference. So Justice Sotomayor preferred people who had worked out in the real world. I think there was both a component of a little bit of what Justice Kruger was talking about, which is the ability to have more people speak to who you are, both as a person, as a lawyer. And then I think there was just another component to it, which is she just wanted people who had been in the real world. And then Justice Gorsuch, we have a joke on the committee that at some point we're going to run out of professors who want to clerk for him because he's just sort of cycling through sort of old law clerks, professor. And so he also prefers that. And so I don't know if I can pinpoint sort of a broader trend, but it seems as though the justices are increasingly preferring folks of a little bit more experience, which in my mind makes sense. I mean, you want folks who are inexperienced enough not to be set in their ways or to have egos that are too large, but sort of experienced enough to also be able to bring more to the table, I think.
Does that raise a question about kind of the metaphysical purpose of a Supreme Court clerkship? Because certainly in the early days, it felt as if a Supreme Court clerkship was really almost avowedly an apprenticeship, right? An opportunity for somebody fresh out of law school to kind of do this as very much a first experience in their careers. Now, not surprisingly, it seems like the justices, think the more experience, the better, right? Because these people are helping them with their jobs. And obviously, if you're choosing between somebody who's fresh out of law school, who's never litigated a case, and somebody who's had years of experience in government or at a law firm, you would ordinarily choose candidate number 2. Do you have views on this as a law clerk hirer?
Also, my chamber staff is composed of both permanent law clerks, which the Supreme Court does not have. I have 2 of those, and I have 3 annual law clerks. To my mind, it's a sort of I've lived experience of sort of the best of both of these models. I think there is real value to having experienced clerks who are deeply familiar with the body of jurisprudence that is coming up repeatedly in the cases, who have the institutional memory. It is helpful. But at the same time, I think it's healthy for the institution to have people come in who aren't deeply steeped in a particular way of thinking about how the law works, and who are sort of willing to do the background work, and have the sort of the curiosity and drive to figure out when these questions come up as to which there aren't clear answers, or as to which different judges across the country have disagreed, how have we gotten here? What are sort of the threads of the law that have started to disentangle, and how do we think about these questions as a matter of first principles to figure out how the law should develop going forward? And I think there is a lot to be said for having a little bit of the outsider sort of fresh perspective in the mix in taking on that task.
It's a bit of a specialist job, And so I think Justice Sotomayor's idea that you should hire people not who have done 3 clerkships, but who have worked in the world is a very healthy idea. But if you think about it, somebody who's clerked 3 times, I mean, this is a weird job. You have to not want publicity for yourself. You have to want to be bound by a very strict confidentiality rule. You have to pretty much want to just go to the library and read briefs and research and write and not be actively involved. You only see 5 or 6 people, maybe your co-clerks with other chambers. So maybe people that are successful in 2 clerkships are better at this specialized job. But boy, I don't know a lawyer who doesn't feel badly about something they did in their first couple years out of law school. And those are people who are now handling some of the most important social cases. And, the Supreme Court is our problem solver, right? They granted cert in an abortion case this morning, and that's going to affect a lot of lives. So I'm with Justice Sotomayor on this, that it's a healthy practice to hire people who've done something else. I don't know that 3 clerkships are the something else that I'm most interested in looking at.
John, I'll give you the final word on this question and on the panel.
What's the one word?
You can even have more than one. We'll treat this like a Supreme Court advocacy. You can have the final 2 minutes without interruption.
So I turned 30 on the first Monday in October the year I clerked, and I was relatively experienced. I'd spent 2 years at the Justice Department, and Justice Kennedy would periodically say, "Now let's hear what the member from DOJ has to say." And I think that there's a lot of benefit to have some experience practicing. I think that my years at DOJ were more beneficial than my time spent clerking. But I do think that there is a virtue in getting people who are still junior enough to be terrified. Because I think a very important thing is to be worried enough about screwing up that you are extremely careful about, running down things like potential for mootness and vehicle problems in cases and things like that. And I think there is kind of a sweet spot for doing the clerkship where you have a little bit of experience, but you're still willing to work like an insect to make sure that everything is done correctly. Because if you can make enough screw-ups even if you're working that hard.
Great. Well, with that, what a wonderful and collegial discussion. And please join me in thanking our distinguished panelists.
Thank you.
And I'm led to believe that the next panel will start at 2 o'clock.
Exactly. Perfectly timed and very well done.
Hi, how are you?
Oh, yeah.
Thank you all.
You have such the best speaking voice.
Hi.
My name's Ellen April. I clerk for Justice White, OT 81. I want to ask you.
I mean, your questions are also great, but just the voice makes me want to hear more.
Well, I rarely had a panel where I felt like my job was to get out of the way more than that. So you guys can
Well, I wanted to hear more about school.
Well, that's a subject for a whole other day. So maybe after dinner tomorrow. So I hope to see you all.
Stay in the audience and watch the rest.
Yeah, I unfortunately have to get back to the office, but I'm sorry to miss these panels because I look like they're really great. So.
And are you sticking around for the dinner?
You have a good nucleus of your co-clerks here.
Yeah, so I also do that. So we've actually seen the Stevens courses.
Yeah, I know. Yeah, I was talking to Roberta about policy. Went through that experience just as time passed away. It's really tough. I was surprised at how emotional it was.
But it was also
Yeah, and I wish I meant to pull on that thread a little bit.
Well, there were less writing.
Worked for their former judges. I mean, there are a lot of aspects. Jeff's looking nervous. We're blocking. Yeah, well, thank you. I hope that was okay. I think we could pour water on the Supreme Court clerkship program, but those are. We had 4 minutes.
But then was that him or was that?
I'm sorry, I have to run. Oh, no. 5 o'clock for 6:30. He was thrilled.
He had 2 high years. He had 2 high years. Yeah, but it was at the role. Because there was a real problem. And there was that whole article that was the expose on the Yale system.
Best friend there.
Right. Well, it's changed, but it is what it is.
I saw you.
Give me a second. Yeah, we didn't see it, so I didn't. Yeah, of course you did. Of course you did. Of course you did. Yeah.
Yeah, thank you. nice to see you. How are things? How are you? I guess that's right. That's all I do is moderate. So this is it's a lot better than being the panelist, as you know. All you have to do is come up with like 5 questions. How are things? Everything going well? Excellent. William and Harry.
Hi through Jeff. So great to see you. So glad you're here.
Hey, sir, how are you? Hey, good to see you. How are you? Good to see you. Yeah, absolutely.
Okay, great job again.
Yeah,
Thank
see you tomorrow.
So are you going to introduce the members of the panel?
No, I'll just introduce you. And you can do it quickly, please. Okay.
Thank you all very much for coming. I think we're going to get started with the next panel.
Ladies and gentlemen, welcome to panel 2 in our symposium celebrating the 100th anniversary of the Supreme Court clerkships. For those of you who've just joined, I'm Jeffrey Rosen, the head of the National Constitution Center in Philadelphia and a law professor here at GW. The National Constitution Center is so honored to have convened this extraordinary group of former Supreme Court clerks to celebrate the 100th anniversary of the federal statute creating the Supreme Court clerkships. And we've just heard a wonderful panel about experiences during the clerkship, and now we will hear one about life after the clerkships. And moderating this panel is Joshua Matz. He is publisher of the Take Care blog. He is an adjunct professor at Georgetown. He is a very distinguished constitutional lawyer and the author of an important book on impeachment, which he came to the National Constitution Center to discuss with riveting detail. Recently, he clerked for Justice Kennedy. Take it away, Josh.
Hi, well, thank you all very much for coming. And if it's okay, I'd actually like to start by introducing my colleagues on this panel. So I'm joined today by Julius Janikowski, who clerked for Justices Brennan and Souter. He's a former chairman of the FCC and now a managing director at the Carlyle Group. Judge Cheryl Ann Krause, who also, like me, clerked for Justice Kennedy, did a stint in private practice, worked as an AUSA, and is now a judge on the U.S. Court of Appeals for the Third Circuit. Following is Gretchen Rubin, who clerked for Justice O'Connor. She is the author of many best-selling books. If I listed them all, we'd be here for the next few while. She's also the host of the Happier podcast and the creator of an app called Better, which I'm excited to learn more about. And finally is Thuru Vignaraja, who clerked for Justice Breyer. His career includes time working as an AUSA. He headed the Major Investigations Unit in Baltimore. He served as the Deputy Attorney General of Maryland. He's now a partner at DLA Piper and also a candidate for the mayor of the city of Baltimore. So thank you all very much for joining. Today we're going to be discussing life after clerking. Now in some ways this is a strange topic because literally every clerk has had a life after clerking. And their paths are as diverse as the professional world is broad. They encompass every field and level of government, every field of practice. They have extended far beyond the law. In other words, they're just like you. And at the risk of fighting the premise of this panel, there is something to be said for the fact that SCOTUS clerks are really just like all other law school graduates. They often come to the court early in their careers. They may have had limited exposure to the wider world of practice. And they too, we too, face plenty of hard decisions about what we want to be when we grow up after our time at the court. Still, there's no denying that the experience of a Supreme Court clerkship is powerful and occasionally transformative. To clerk at the court is to be entrusted with an awesome responsibility early in one's career. The cases are hard, and they encompass virtually every area of federal law. The stakes are high, not only in blockbuster cases, but in every case, since these are the cases that shape the rules by which we live. The pressure to get it right and to serve one's justice well is relentless and intense. And that's not to mention the small matter of sustained sleep deprivation. Now, don't get me wrong. Clerking at the Supreme Court is an amazing opportunity for those who are, as the saying goes, struck by lightning. It can be fun and exciting and profoundly enriching. It can also be maddening, merciless, and at times overwhelming. To complete a clerkship at the court is, in some ways, to emerge from a blast furnace, unlike any other, one that inevitably shapes those who pass through it. And on the other side of that blast furnace, I received the same piece of advice over and over again. That was the coolest job you will ever have, by far. Nothing else that you ever do for the rest of your life will ever compare. And I'll be honest, that was super depressing advice to get at the end of my Supreme Court clerkship. You know, I guess it's all downhill from here. Fortunately, that advice was just misplaced. The role of a clerk is to serve and advise, to execute another's vision, to act as their agent and their fiduciary, bound by strict rules of confidence and acting only within the confines of those issues that reach the court for resolution. That's a thrilling experience, but the wider world has a lot more to offer. And like many clerks, in approaching that world, I've benefited greatly from lessons and insights from the justice for whom I clerked, Justice Kennedy. And so today, if it's okay, I'd just like to talk about a few of the lessons that I took from my clerkship experience and meditate on how they've shaped my practice in the cases that I've chosen to work on or been lucky enough to engage with. As I think most clerks to Justice Kennedy would say, the first lesson of life in his chambers is that civility is both a virtue and a paramount concern in addressing hard questions. Now, civility can be a challenging virtue to live, especially in these polarized times when accusations of bad faith and hypocrisy are ready to hand, and in which more and more Americans are quick to assume the worst of their fellow countrymen and women. Working for Justice Kennedy was a sustained education in living civility, in the way he treated us, in the way he expected us to treat each other, in the way that we approached the cases before us, and in the way that we interacted with other chambers. And that has carried through to my own practice. I work on issues that raise tough questions about the intersection of LGBT rights and religious freedom. I currently represent some of the victims of the attacks in Charlottesville in a lawsuit under the Ku Klux Klan Act against the white supremacists who attacked them. These are not always lawsuits in which litigants and opposing counsel show civility, in which they show respect for our position, or in which it even seems like there's a middle ground to be had, in which we can find common values and virtues and build out from there. One of the lessons that I bring to all of these cases is that part of the role of a good lawyer is to treat everyone with whom they interact with respect and civility, and to try to present issues to courts and to judges in ways that, if I can just think about how to say this, in ways that appropriately reflect the balance of equities in the case and show respect to all sides, even when you're advocating for only the one. Not every case is an all or nothing adventure. Justice Kennedy was committed to that proposition, that there can be balance in the law. And that's something that has very much informed my own work on some of those kinds of questions. The second lesson that I took from Justice Kennedy is that there's more to the world than the federal government. This was something that Justice Kennedy cared deeply about, and he thought, and I think rightly so, that many former Supreme Court clerks, and indeed many lawyers and commentators, unduly fixate on the federal government as though it's the only thing that matters, and on the federal courts as the only place in which justice can be had and equities can be resolved. As we all know, there are 50 state governments in this country, not to mention the District of Columbia, in which extraordinarily important work is done. I have taken many cases at the state level, ranging from efforts to affirm the rights of transgender persons in Iowa, to uphold the right of women to come forward with Me Too statements in the state of Virginia. And I think, as is the case for many former Supreme Court clerks, my practice has trenched well beyond the federal judiciary, where the question is not only what did those 9 people up there think of this, and into many other fora in the states. I've also, in that same context, worked hard in areas of civil society where justice can be done. And this was something that, to Justice Kennedy, was also very important, that it's not just the states, but also the institutions of American life that you can help build and that you can nurture to try to advance the cause of liberty and human dignity. And that resort need not always be had to the courts. And so, I mean, in my own practice, I've worked hard with Roberta Kaplan, who leads the firm that I'm at, Kaplan, Hecker, and Fink, on helping to build the Time's Up Legal Defense Fund and the Me Too movement. and in shaping other institutions like Integrity First for America, which is devoted to combating the scourge of white supremacy in this country. Those are areas in which a lot of good can be done without necessarily resorting either to the federal government or the federal courts. The third lesson that Justice Kennedy would often impart on his clerks is that it's important to be a good lawyer, but it's also important to be a good citizen and a good teacher, that lawyers have obligations that transcend merely mastering doctrine and winning the cases before them. Now, don't get me wrong. Justice Kennedy loved the law. He loved doctrine. He would often say that if he could have any job other than the job that he had, it would be a district court judge. He was fascinated by the way that the law works when the rubber hits the road and you're actually in the court making things happen. And, I have my share of that, wonky love of the law. Who doesn't enjoy a good equitable tolling brief? I sure do. But the fact is, Justice Kennedy was as much a poet and a professor as he was a legal engineer in how he thought about the law and in how he thought about the role of lawyers. Some cases require a 10,000-foot view. Sometimes the highest calling of a lawyer is not just to litigate, but to teach and to serve. That's part of what led me in my own practice to go and find an opportunity to teach at Georgetown Law School, where I teach constitutional litigation, and where I try to carry forward his lesson that one of the ultimate role of courts is not just to make the law, but to teach the law and to expound on the lessons of the Constitution and of the framers' design. The final point that Justice Kennedy would often emphasize in our conversations in chamber is that the structure of our government exists to protect and is the guarantor of freedom in the United States. He cared deeply about individual liberties cases, but few cases woke him up and inspired him the same way as cases about the structure and division of power within our constitutional system. Because as he recognized, the rules that mark out the plan of our government are the rules within which all other freedom and equality and dignity is protected and preserved or not. And these are, I think we can probably all agree, difficult times for American democracy. We may not agree on why they're difficult. We may not agree on who's to blame for the difficulties. But my suspicion is that many in this room would agree that these are challenging times for our democratic system. And it's in no small part because of Justice Kennedy's teachings and inspiration to focus not just on one-off cases, but the underlying health of the system, that I've steered significant parts of my own work and practice in that direction. A concern for accountability and integrity in government led me to help design and bring the first cases against the president under the emoluments clauses, where I now represent plaintiffs both in New York as well as the District of Columbia and the state of Maryland. It led me to work on cases involving efforts to enforce congressional subpoenas against the executive branch, and now to represent and help advise the House Judiciary Committee. And last but not least, it led me to write a book with Professor Larry Tribe at Harvard that Jeff mentioned, To End a Presidency, the Power of Impeachment, in which the question that we fundamentally sought to answer was how the impeachment power can work and should work in a society as polarized as ours and in a period of democratic decline. In many ways, I think one of the highest callings of a lawyer is to uphold not just the rights of any litigant in a case in front of them and to advocate for those rights, but also to defend the rule of law and the institutions of government on which the rule of law is based. That was one of the guiding commitments of Justice Kennedy's career, and I hope it will remain one of the guiding commitments of my own. And with that, we will turn to Julius, who will talk a bit about his background as at the FCC and the Carlyle Group, and I know many other exciting fora. There were too many to list, and so I just got to a point where I said, he'll cover it.
So, as Josh said, I clerked for Justice Brennan as a retired justice, got loaned to Justice Souter, and then clerked for Justice Souter. And just listening to you and being on this panel reminded me that when I clerked for Justice Brennan, it was obviously at the tail end of his career. I think I was the 100th clerk. And there were, I don't know if it was annual, but I remember one reunion of Brennan clerks. And I remember thinking, those former clerks are so old. Although they've had really interesting careers. And I haven't done this math in a really long time, but it's been 27 years since I clerked. And so I think I'm now in that category. It's a little bit strange. I'll tell the story of my career since clerking. As you'll see, it's about 10% strategy and 90% serendipity. But it's been great fun, and I feel as lucky and privileged at the career that I have as I did when I was at the Supreme Court getting those clerkships. Like, I'm not the only one with a story similar to this, but my parents are immigrants, Holocaust survivors, and the chance in this country to go to a law school like Harvard and to clerk at the Supreme Court was really an amazing thing. And actually, at the Supreme Court, one of the most pleasurable moments was bringing my parents to the court and explaining to them why Nazi Germany could never happen in the United States because of the Supreme Court, which I assume is still true. And I've had that chance with my parents over the course of my career. So I loved clerking. I loved every minute of it. I loved the intellectual challenge. I loved the subject matter. I loved the people. It was all great. It wasn't my first job. Like some other people, this is a topic in the prior panel. I worked for 3 years between college and law school. I worked for Chuck Schumer on the Hill. I worked for the Iran-Contra Committee, which at this point I run into people who don't remember it, but I worked for that. That was fun. And over the course of my Supreme Court clerkship, I begun to realize that I wasn't sure that I wanted to have a conventional legal career. While I loved it, I begun to believe that for me, it would be more enjoyable and rewarding to commit not to expertise in and around the law and legal practice, but actually to commit to expertise around a subject matter, and then have a lot of optionality around that over what I would do for the rest of my career. And the area that I picked was technology, media, telecommunications. There was a few reasons for that. My dad did immigrate here and became an engineer, and I inherited some of that, the love of tech. I'd always been an early adopter of different kinds of technology, and kind of in a happy coincidence, when I was clerking, it was just at the very early days of the internet. So the internet was up and running if you could find a computer in the basement of a school like GW or Georgetown. It was before browsers. Actually, remember, literally this happened when I was clerking. A fellow named Ben Wittes, who's still around and writing interesting stuff now, very early to the internet. I don't remember how I knew him, but he said, "Hey, come with me after after clerking, and I'm going to show you something really interesting." And he showed me the internet in 1992. And then when I clerked on the DC circuit, I had some interesting FCC and other technology, telecom related cases. And when a fellow named Chris Wright, who was in the Solicitor General's office when we were clerking, he sent a note around to the clerks my year saying, "Hey, I just took a job as Deputy General Counsel of the FCC. Does anyone want to come work at the Federal Communications Commission?" At that time, Gretchen will remember this, not a lot of Supreme Court clerks went to work at the FCC. It was regarded as a backwater agency. So yes, well, you can tell that part of the story. But it fit into something that I had been thinking about, and I went and talked to Chris, and one thing led to another, and I got hired as into the general counsel's office at the FCC, and pretty quickly the chairman at the time, Reed Hunt, said, no, you have to come work for me, and I did that. And so I worked as chief counsel for the chairman of the Federal Communications Commission for 3 years or so in the late 90s. It was a great, really interesting time in that space. It was the first auctions of spectrum. It was the Telecommunications Act of 1996. It was the first time digital came up in the world of communications. Worked with some terrific people. It was great. And then I had to figure out what to do next. And I decided that I wanted to move into the business world and get away from some of what I had done in Washington and to try something a little bit different. And I decided that I wanted to find a job, which I was too young to realize didn't really exist, but I looked for it anyway. And I wanted to do something where I would be general counsel of something at a company and also have very clear business responsibilities. And so I went and talked to various folks and got lucky and actually got an offer to do just that. The offer came from someone named Barry Diller, who at that point was just starting a company that became IAC Interactive Corp. Previously, he was known for being at ABC, where he invented many things, Movie of the Week, the miniseries. He created Fox News, and now he was starting a new company, which many people were dubious about. But I took a bet on that because he offered me the job that I wanted, and I became general counsel and the head of corp dev and biz dev for his TV operations. No idea what I was doing, but had a great time doing sports rights deals, setting up TV stations. And after a couple of years where he had done a number of acquisitions at the parent level, this is a public company, he came to me and he said, I want you to be general counsel of this company that I'm building. And I said, Barry, I came here because I wanted to move away from law into business, and so I don't think that's what I want to do. And eventually I realized I didn't have a choice. He said, he said many things. He'd created an office of the chairman with one other grown-up like him, a fellow named Victor Kaufman, and two kids. The other kid was a guy named Dara Khosrowshahi, who went on to run Expedia and now Uber. And the four of us worked in that office of the chairman. It was a little bit like a clerkship in that there was like 1.5, justices, and we were sort of the law clerks doing a lot of the stuff. Maybe we had a little more responsibility. But I did that for a while. Eventually, I moved from general counsel to become chief of business operations of the company. At this point, it was a fairly large $6.5 billion multi-business internet e-commerce digital media company with companies like Expedia, Ticketmaster, some traditional media companies, entertainment companies. And then we decided to break up the company into 6 separate public companies. If any of you were shareholders at the beginning of that ride, it would have been very good by the end of it. And after that, I had been working really hard for a very long time. I tried to retire. And as Jeff knows, I was commuting between New York and DC at the time. I came back to DC and put together a portfolio of fun activities. I started an incubator here in DC for early stage tech companies, served on some boards, and spent a bunch of time with a law school friend and classmate named Barack Obama, who had just gotten elected to the Senate. And I thought I might have some advice for him about the role of that technology could play in politics. This is a topic he and I had been talking about for some time. I can come back to that later if it's of interest. And also about tech media telecom policy and various ideas on why he should run and why he might win. Didn't really expect him to, but got very involved with that effort. And then he won. And then asked whether I'd come into government, and I was open to it. I wasn't looking for it. He said, come work at the White House. I said, I don't think I want to work at the White House. He said, what do you want to do? I said, well, I used to work at the FCC, and I think I should run that. And he said, okay.
Important lesson on asking for what you want.
So that worked out, and I became chairman of the Federal Communications Commission in his first term. It was a wonderful experience, which we can loop back to. It helped a lot that I had been at the FCC, that I'd been at the private sector, that I had some time in Congress. Those 4 years were filled with net neutrality, wired and wireless broadband initiatives, cybersecurity, on and on. And then that was exhausting. And I tried to retire again after that, and realized that I was old, but not that old, and it was a little bit too early to retire. And one thing led to another, and I took a job as a partner at the Carlyle Group, which is where I am now. I'm an investing partner, investing in and buying in companies in the US and around the world. Continuing in the same space that I decided to be in at my clerkship, tech media telecom. That world has evolved, and it's been great fun along the way. I had a chance after the FCC to serve on the President's Intelligence Advisory Board, where technology was also not unimportant. And I serve on some boards outside of Carlisle, also where technology is a theme. So it's been great fun. I'm sure I'll think about retiring again soon, and start another career. And I'll just conclude by trying to answer the question that Josh posed, which is, what was it about my clerkship that helped inform the rest of my career? And the 3 ideas that I'd point to are, one, discipline. And you know, as we all know, as you all know, discipline is just a key attribute of just surviving the job at the Supreme Court, much less doing it well. You know, any mistake that one makes is immediately exposed. And so you learn analytical rigor, discipline, hard work. Second, humility. You know, you learn humility in a number of different ways in a Supreme Court clerkship. Part of it is just the amazingly talented people you work with, both as colleagues and on the bench itself. Humility is a good thing to carry around with you as, you know, one tries to build a career. And then finally, I think I took away from the Supreme Court clerkship audacity. And sort of by that I mean the idea that anything is possible. You know, that if, you know, a child of immigrants and Holocaust survivors can, you know, clerk on the Supreme Court and give advice to justices, you know, you really can do anything. And if you can survive a year with such an amazing group. So if something seems interesting, worthwhile, important, why not? And with that,
I think
I'll let someone else talk.
and that person will be Judge Krause.
Well, I'm going to take an approach that's less chronological and perhaps speaks more generally to aspects of a clerkship that inform people's careers. Is your button pushed? I don't know. Yeah. Is that better? Yeah. The Supreme Court clerkship is different in the kinds of cases, in the number of cases, which is a lot less than we have on our docket and then certainly district courts. And in the intensity of it and some of the experiences of it. But many aspects of it are also, can also be generalized to clerking elsewhere, including on state courts. For me, the effect of a clerkship was, first of all, direct and practical in that it prepared me for this job. And when I started this about 5 years ago, I had some idea of what it might look like and some ideas about how to run a chambers that were very much in the vein that Josh expressed in terms of the lessons in civility, the ways to interact with clerks, to bring clerks from many different perspectives together, to work through issues from all angles, and to think about that experience as one that carried responsibility for mentoring them, as well as the focus that we have on deciding cases properly under the law. It also exposed me to areas of law that I had some exposure to in law school, but really thought of as quite foreign, including criminal law. And it was in the course of clerking, initially on the Court of Appeals, that I realized these 20-something AUSAs who were coming to argue in front of us were speaking to what they actually did at trial. And the idea that I could, even in the next few years, be running a trial and then arguing the case in the Court of Appeals was really intriguing and exciting. And it led me pretty quickly after my clerkships ended to go to the U.S. Attorney's Office in the Southern District of New York. That would not have been on the radar for me had I not seen that in the course of clerking. And the other very practical effect is the network that one gets. It's an extraordinary network, as the last panel was discussing at the Supreme Court, among Supreme Court clerks. But it's also an extraordinary group of people who choose to clerk and have the remarkable opportunity to clerk at any level of the court system. The network that flows from that, as I try to encourage my own law clerks now, they can't foresee the kinds of opportunities that will provide down the road. And I have no doubt that I would not be in the job that I'm in, but for one of my co-clerks who had spent some time in the White House counsel's office. And when I wanted to do some teaching, initially on the side, as I was working at the U.S. Attorney's Office, and then have continued to do that as a lecturer at various schools, the ability to call up someone who is now there as a professor who was a co-clerk, or the dean of the law school after a few years, in the case of Columbia, and to have those openings to teach what I would like, and the support of the faculty in doing it. It also, even in the course of private practice, meant there was this array of experts in various fields that were happy to answer calls and share their views, because it's a real bonding experience, and it's in formative years as a professional. The experience of clerking also, I'm sure, made me a far better advocate. I spent many years in private practice after I was clerking, a visiting scholar at Stanford for a bit, and then at a firm very briefly, then the U.S. Attorney's Office, and then many years in practice until I was appointed to this position about 5 years ago. One of the ways, as some have spoken to, is you see issues from all sides, far beyond what you do in law school, of taking one side and the other. It really is tracking down every lead and thinking about it from different angles and thinking about more broadly the consequences of things you do as well. You have exposure to the good and the bad of advocacy. And it's in a way that you can learn and understand beyond what's just as an academic notion, because as a law clerk, you actually know the case. You know the issue, and sometimes you know it better, and the record even better than the attorneys who are coming to argue. And so you really can evaluate when the judge asks a question and counsel's giving an answer, do they get it? They understand where the judge is coming from, and do they understand how they can best position their answer to both advocate for their client and gain the confidence of the court that they've really thought these issues through. Prioritizing issues is another one, and at the Supreme Court, you realize quickly that the depth and quality of argument is far more important than the quantity of argument. And I see that now when we get briefs that are raising 7, 8 different issues and touching on them only briefly, as opposed to a handful that are really well-researched and well-argued. You learn to be responsive and to be conversational. The best advocates who came before us at the court were those who, while I'm sure they were terrified, it's the term that was used, if I can, on the last panel, they were able to conduct themselves in a way that was really a conversation, respectful, but in many ways expressing that they were an intellectual peer in trying to get the right answer here and trying to help the justices or judges, as the case may be, figure out how the law should be evolving in this area. And in terms of being an advocate, that's the other point I wanted to touch on, and that's, I think, the course of clerking, and particularly on the Supreme Court, where you're looking at it and perhaps informed especially by Justice Kennedy's views, but you're really looking at it, zooming out to see the broader perspective, and zooming in for the concrete principles or doctrine that needs to be applied. But the ability to zoom out and think about a case and your advocacy for a client in that case, not simply to win that one matter, but to realize where it falls in the development of the law itself. And that's part of what judges are thinking about, the continuity of that, and adhering to stare decisis, and not deciding things that weren't briefed, that have not been thoroughly thought through because of damage that might be done, right? So the ability to zoom back out, have that perspective as an advocate, and to craft arguments that way, and to respond to questions from judges that way, I think was very helpful to me in private practice and with various volunteer work and work for the city and the Board of Ethics of the city that I did for several years. And finally, in a way that is less tangible, but in many ways more profound, the clerkship, it taught me some things about life. One is that it humanizes figures of authority. And you realize in the course of clerking that judges and justices are human beings. They have families. They're juggling things like all the rest of us. And so there's an evolution, I think, that goes with that of moving from anxiety and awe to some admiration and respect for human beings who are dedicated to the law, who are working very hard to try to get things right, and who are using the opportunity they've been given, the privilege of serving in that platform, to also better the institution of the legal profession, whether it's through academics or community service or civics education. Another is the confidence and competence that you get just having to play devil's advocate with someone of that intellectual stature. And finally, the broadening of the meaning of success, which is something I think we really need in this profession. And that's to say that co-clerks, there are co-clerks in the law, in a wide variety of things in the law, but there are also co-clerks of mine who went into private equity or became novelists or school administrators or opted out for a period or permanently from the office environment and decided to, after a Supreme Court clerkship, for example, to focus on raising a family and using the skills and insights that they had gained for community service and volunteer work. So gaining that sense of both competence and autonomy, I think are things that are very helpful and useful things to import back into the legal profession at a time when the happiness and satisfaction in the profession is struggling in many ways.
So I think that's actually a wonderfully natural transition to our expert on happiness. So please take it away. I think we have about 10 minutes left for each of you both, and so I think we're right on track here.
Okay, great. As Josh mentioned, I have written I've published 9 books of nonfiction, and I have 3 novels which are safely locked in a desk drawer, so they will never see the light of day. And I have a podcast called Happier. And this is nothing that I would have envisioned back when I was in law school. I did not anticipate that I would end up here. So I went to Yale Law School. I was editor-in-chief of the Yale Law Journal. I clerked up for Pierre Laval in the Second Circuit, and then came to clerk for Justice O'Connor. And there I was. And one of the things that had always happened to me throughout my life is I would get intensely focused on kind of weird little issues. Like I just went through this with color. I got really obsessed with color, and I'm obsessed with aphorism. If you have any favorite aphorisms or proverbs, please hit me up because I'm collecting them. So this was something that I knew about myself. And when I was clerking, there was a day where I went for lunch, during my lunch hour, to go for a walk around the beautiful Capitol Hill. And I was looking at the dome against the bright blue sky. And I asked myself a rhetorical question, as one does. And I thought, what am I interested in that everyone else in the world is interested in? I thought, well, power, money, fame, sex. And all of a sudden, these words, power, money, fame, sex, just kind of locked into my mind and overwhelmed me, and I became intensely interested. So there I was clerking the Supreme Court. I was like working. And then when I had some free time, I would stay late or I would come in on the weekends because this was before the internet. So I would run giant searches on LexisNexis on Power, Money, Fame, Sex. Also, little known perk of being a Supreme Court justice is you can actually check out books from the Library of Congress. Like everybody else has to look at them in the library, but if you're a justice, you can check it out. So I would just request all these books from the Library of Congress. And like I would ask for books like Deep in the Heart of Texas, the true story of three sisters who were all Dallas Cowboy cheerleaders. And what the librarians thought about why Justice O'Connor felt the need to check that out, they never asked. It's actually like an extraordinary meditation on fame. So I was doing this in the background. And you know, I had done this throughout my life, so I knew what this felt like, but this was just getting bigger and bigger and bigger. So I left my clerkship. I went to go work for the FCC, where Julius and I overlapped. But I was continuing to work on it, and it finally occurred to me, this is the kind of thing somebody would do if they were going to write a book. And so I went to Borders downtown and checked out a book called something like How to Write and Sell Your Nonfiction Book Proposal. And I just started following the directions. And so I was finishing up law, and I had reached the point where I thought, I would rather fail as a writer than succeed as a lawyer. And I don't know what I would do in law. And if I'm ever going to take my shot, this is the time. Because if I take another law job, I don't think I'll ever risk it again. I think I'll just be too deep into a path. I won't want to step off and do something like write a book. So this is my time. And my husband and I were moving back to New York, and he was leaving law too to go into finance. And he was at GW. He took financial accounting at night. And we were in New York, and the day came where we got our notices from the New York State Bar Association. Time to pay the bar fees. And I looked at my husband and I said, are we going to pay our bar fees? And he said, are you kidding? Of course not. And I was like, okay, this is really happening. So I got an agent and started writing books, and that's what I've been doing ever since professionally. But when I look back about what was it about sort of the extraordinary experience I had as a clerk and as a lawyer, part of what it was for me was the level of excellence. It is rare, and as you get older, you realize how rare it is to be involved in something where truly every single person is straining with all their might to work at the uttermost of their capacity. And even people who profoundly disagree with what some of the justices believe and argue, I don't think anyone would say that they're not doing according to their own lights what they believe to be the best for their country and trying to do their best work. And so that standard of excellence, I felt, was just a rare opportunity and also taught me the pleasure that comes from working at that level of excellence. And also the logic of it. I mean, I don't know about you, but I read stuff and I'm like, this is not you're not arguing something logically. You're asking me to assume something that you haven't proved. And like, I reject everything because I reject your assumption, like just the rigor of it. And checking sources, all that has paid off as a writer. But I have also learned some negative lessons, which perhaps you will share my pain. Legal writing, the turgid, the convoluted sentences, the jargon, and it just reading all this stuff, the scholarship, the case law, the briefs, everything, just made me profoundly commit my life to clarity. And I just spent so much time like, can I cut out some of these phrases? Can I say whisper instead of said softly, et cetera, et cetera. So I feel like I really learned that from legal writing, seeing how much more efficiently and effectively people were able to persuade when you could understand what they were trying to communicate easily instead of struggling to understand what they were saying. So that really showed me the power of persuasion comes from clarity. Now, I clerked for Justice O'Connor, and there's two things that I really was very moved by with Justice O'Connor. One was, you know, she was an icon. She was a Supreme Court justice where people recognized her in the street. She was this figure. But someone mentioned humility, and she had tremendous humility. And one of the things that was sort of a tradition in her chambers is we would celebrate birthdays. You know, she's sort of a party-giving type of person, so it was always a big deal in the chambers. And the year before, the clerks had given her a birthday book. You know those books where it's like your birthstone and your astrology sign and like funny things that happened in history. So they'd given that to her. So my year, we were looking it up for the first time, what happened on our birthdays. And on her birthday, she said, okay, well, tell me, who important was born on my birthday? And I open it up, and I'm like, it's you, Justice. And she got a very strange look on her face. And I thought, it's strange to be Justice O'Connor. But then she told me something about happiness that I have never forgotten. So I read about happiness a lot. And so I was having lunch with her, or stopped by her chambers or something. And I said, okay, Justice, so what do you think is the secret to happiness? And right away, no pause, she clearly had thought about this before. She said, work worth doing. And I think the more I have thought about that over the years, the more profound and true it seems to me to be. That work worth doing really is a secret to happiness. And I think one of the things about the clerkship is we do feel like we are doing our best at work worth doing for ourselves, our justices, and we hope for the country. So it was a wonderful experience.
Well, nothing brings a moderator greater joy than someone who finishes exactly at the 10-minute mark.
I am an upholder. For those
Rue,
of you who-
take it away.
Yeah, thanks so much. What a privilege to be here. And what an honor it was to be a clerk. I actually want to spend a minute, though, because I do see some students in the room, reminding people how much a Supreme Court clerkship may not matter. Because I think so much of what we become as lawyers, as adults, as professionals, is defined by things that happened before and after. I am also an immigrant. My family were refugees from Sri Lanka. And we came over when I was 3 years old, escaping a civil war. And my parents got a chance in Baltimore City. My parents were both teachers. My mom retired at a reasonable age. My father taught at a bunch of different schools in Baltimore City and retired as the oldest teacher teaching in the state of Maryland. He was 80 years old. He's 83 now. He doesn't look 83, he doesn't act 83, he doesn't like me telling people he's 83. But that's the tradition in which I was raised. I went to public schools myself, and then I went from some tough schools to Yale for college and Harvard for law school. I was president of the Harvard Law Review before your friend Barack Obama made it cool. And then I devoted myself to public service. And I sometimes think about whether that would have been that different if I had not gone on to clerk for Guido Calabresi and for Justice Breyer. And I'm not sure. I thought I was going to be a law professor, and then while I was clerking for Justice Breyer, we had a case involving school segregation. And naturally, because his father was the lawyer for the San Francisco School Board, and my parents were teachers at some hyper-segregated schools in Baltimore, which was a school like the one I had went to as well, that was naturally the thing I devoted a lot of my time to. And at the end of the year, the plan, so well laid as president of the Harvard Law Review, clerking for Guido Calabresi and for Justice Breyer, to become a law professor was the last thing I wanted to do. And I went to Justice Breyer, and he was so even-handed and even-keeled about what had happened. I was up in arms. I was so apoplectic about the fact that this 5-4 dissent would become the law of the land, and that so much work that he had done was in the words of a dissent. And I said, Justice, I don't want to go become a law professor to write about these things. There's fights to be fought. And he had this reaction. I'm paraphrasing. He said, calm down, calm down. You're here for a year. We do this every year, every year. And he gave me some great advice that helped me define and decide what I wanted to devote my life to. And I think about the lessons I learned. It wasn't just from Justice Breyer. It was from my clerkship with Guido Calabresi as well. And I think the mentorship relationship you form with these judges and justices are perhaps the most important thing. And in that regard, it doesn't matter whether it's a justice or a judge or a law firm partner. There are insights, true wisdom that comes from them. From Judge Calabresi, I remembered a case early on where there's a lawyer from the Justice Department, and they were before the court, and it was an immigration case. The immigrant was pro se. The Justice Department lawyer plainly had the better of the argument. And the question that Judge Calabresi had asked, that Guido had asked, was, counselor, we understand the Justice Department's position, but isn't there another way that this asylum seeker could have gotten asylum? Isn't there another parallel provision? And the lawyer, she said, yes, Your Honor. In fact, I've advised my opponent that he could, in fact, apply if this doesn't prevail through that and perhaps obtain relief. And the judge interrupted and said, can you sit down for just a moment? Can you ask the pro se litigant to come back up? He said, is it true that the Justice Department lawyer actually shared that with you? And he said, yes. He said, you should continue with your appeal, but if I don't get this, there may be a parallel route. And then he called the lawyer back up there and he said, and it was a very, very early memory of mine with Guido, he said, it's nice to be reminded that you don't work for the Department of Deportation, you don't work for the Department of Convictions, you work for the Department of Justice. And he then wrote a letter of commendation to the Justice Department for what this person had done. And that moment stayed with me, right? And you suddenly realize that even at the level of the Supreme Court, where some of the most controversial issues are being decided every year, the way in which these incredibly thoughtful, brilliant jurists approach the most impassioned issues with a level of dispassion is actually really, really important. That they don't, rewrite the entire Constitution. They don't shout and scream from the rooftops. They find a moment of measure. And when I remembered toiling on this important dissent, even then I knew it was important to the justice, I wrote something that was a screed. And he, said to me, no, this will not do. You spend 20 pages writing even-handed history of what happened. No adjectives, no hyperbole, what happened. And then you write 20 pages of even-handed analysis, no exaggeration, no amplification. You say what the law is, and then you can explain why the sky is falling. Because what you've written will persuade the people that are already convinced that you're right. And they will make them very, very angry, but it will convince no one else. And the art of advocacy is convincing people that are on the fence, perhaps even on the other side, that they ought to open up their minds and change. And that was an extraordinary lesson. At that point, I didn't know what I was going to do. I certainly didn't plan on being a prosecutor or now an aspiring politician, but it was an insight that stayed with me for a long time. And then there was a last lesson that I thought was really potent, and I think it's been mentioned a couple of different times. There is a individual humility and an institutional pride that comes with working at such rarefied airs. There is also, and I think the perfect word for it was audacity, there's also a realization that some of the most important things being done in the world are being done by human beings. That the ideas that are hatched by ordinary people. Sometimes 24-year-olds that are a couple years out of law school provide an insight, provide a piece of research, and it changes things. It really can change things and allows you to go off into the world and have a level of confidence that there isn't another room down the hall where the great decisions are being made, that oftentimes you are in that room and you are expected to be that person. And that, I think, has been very, very powerful for me. I'll end perhaps with a story that's both about Baltimore and about how little value a Supreme Court clerkship can have. President Obama didn't waste any time with these Supreme Court clerkships. The other person that didn't do that was a young man from Baltimore named Thurgood Marshall. He went to Frederick Douglass High School, where my father had taught many moons ago. And he then went to Lincoln University. He desperately wanted to go to the flagship law school in his home city, the University of Maryland Law School. But of course, back then, blacks were not admitted. So went down to Howard Law School, and he started studying. And he was discovered by the dean of Howard Law School, Charles Hamilton Houston. Dean Houston was actually the first African-American editor admitted to the Harvard Law Review. So his portrait is the only portrait that sits in the Law Review building. Not Barack Obama, not all of the Supreme Court justices, just Charles Hamilton Houston. And it wasn't because he was the first African-American editor. It's because he discovered Thurgood Marshall. And as a dean, he saw this 1L student who was so brusque and so brilliant, a better oralist, advocate, writer he had never seen, and he mentored him. And he graduated at the top of his class, and he could have gone to any law firm, any clerkship that he wanted to, but instead he went back to Baltimore. And fresh out of law school, he hung up a shingle on a Redwood Street, right downtown, and in his first year, he filed a lawsuit against the University of Maryland Law School for not admitting blacks. He made an argument no one had ever made before. He made an argument no court had ever accepted before, and he won. The University of Maryland Law School became the first graduate program desegregated by an order of the court by Maryland's highest court. And the same argument, a kernel of it at least, that he made in 1932, he made 20 years later when he argued Brown versus Board of Education before the United States Supreme Court, where he changed anything. for me, I am proud of the fact that that kid's from Baltimore. But it's also a reminder that that audacity, that confidence, that you can make an argument no one's ever made before, doesn't require you to clerk on the Supreme Court. It requires you to appreciate that the power of the law and the power of advocacy and the power of insights we saw, day after day at the court, but that lives and breathes in advocacy and in courtrooms and in law schools everywhere.
Well, that was just so stirring that I'd feel silly trying to add to it or improve it. And I know that we're coming right on our 3 o'clock deadline, so I'd like to thank you all very much for joining us and to my fellow panelists for their inspiring presentations.
Yeah.
Yeah, are you here in DC? Yes. All right. We should. Great. Good. Happy to see you. Great. Those are very thick card, right?
Very thick cards. Yeah. Almost mean you're very successful.
Yeah.
It was so defining.
That's the implication. Absolutely.
Wait, deportation?
Yeah, I'm based with a law firm that's in New York, and I'm in our DC office.
So surprising too. I mean, the break from protocol to.
No, I know. I was just thinking that. Like, I wonder if he was a young judge too.
You're obviously involved in a
That
bunch
he would be willing. That's not very judge-like, right?
No, Guido was not. Sometimes not very judgmental.
He was
They represent a lot of
It's very spontaneous.
And we knew we were going to rule against
involvement.
the choice of litigant, right?
Well, because you've got to worry about precedent.
That was
But the person had. That is a beautiful story.
Yeah. I realized he was here tomorrow, and so I remembered, I should tell him.
That's a great story.
I have no
so
idea if
you're
he
running
remembers
for
it.
mayor.
Yeah.
Wait, is Baltimore City different from Baltimore?
It is. Baltimore City is this part that's struggling. Baltimore County is actually doing great.
Oh, okay.
That's
But the
really
city
exciting.
is the city that's struggling. So when
So,
Donald Trump
The
is
Wire?
yeah. Look, The Wire is an amazing series. And
Right.
It very accurately reflects part of the city.
But it's such a work of genius. I feel like it can only reflect. It only makes people more interested. You should have like the Wire tour.
I am a huge advocate. It's a very, very mixed thing in Baltimore. But David Simon, who's not
Yeah.
who lives around the corner, I think did us a service by sort of highlighting the issue and sort of adding some poetry
Well,
what
no,
is
it's
otherwise
like
just really bad.
when they're blowing up the tenements.
Yeah.
And it's like seems like it's this moment of victory, but then there are all these people being like, oh, that's where
That's exactly right.
Life is complex.
Yeah, totally. Where are you based now?
New York City.
Oh, cool. So, well, I promise I'll be in town.
Oh, good.
It's good to see you. Great.
Iterating in my mind and thinking. I just wanted to thank you both for your wonderful
You were great.
I really need to catch up. I know how to reach you.
Okay, good. Okay, good. Yeah. You're not free right now. Do you have coffee right now?
Right. Okay. All right. Good to see you. Thank you for that.
Thank you.
It's great to meet you.
Yeah.
I think we're about to get voted off the stage.
One of them is a famous explorer and the other is a smart. Anyway, let's get together.
What do you do? I came in right at the time. Oh my God. Was the reference to Akila Mark? Well, the idea that the guy never goes to is I know. The extraordinary piece that he wrote was like when he was like a year or two after law school. I mean, the footnote one, not the footnote, but the clause that had Anyway, that's funny. But when I saw live, I think he'll get a chance to write. He's getting interested. So I promise I'll reach out. Thanks. Thanks so much for having me. I was going to thank you. It was wonderful.
If you're wearing heels.
Oh, yes, absolutely.
Okay.
Do a quick picture or afterward. And then
All right, well, I'm going to kind of mess it up with this injury.
Actually, go on this side. Let me see that.
All right, good, good.
Yeah, you can kind of tuck it behind.
Yeah, look at that.
thank you very much.
Thank you.
Welcome to the third of our panels in this rich and illuminating day-long discussion celebrating the 100th anniversary of the Supreme Court clerkships. Once again, for those who are just tuning in, I'm Jeffrey Rosen, the head of the National Constitution Center in Philadelphia and a law professor here at George Washington University. The Constitution Center is so honored to convene former Supreme Court clerks to discuss how their clerkships influence their lives. And I am so honored and thrilled to sit here with two of America's greatest appellate judges, two distinguished legal intellectuals and jurists who I've just had the pleasure of getting to know and discuss the law with at the Constitution Center and over the years. Both were Supreme Court clerks. Both are acclaimed across America for their opinions and their rigor and their approach to the Constitution. And I just can't wait to ask them how their clerkships influence their approach to judging and to the Constitution. So that's just what I'm going to do. And I'll briefly introduce them by saying that Judge Jeffrey Sutton sits on the U.S. Court of Appeals for the Sixth Circuit. He is the author of such an important book. He came to the Constitution Center to discuss it, and I want you all to read it because it will transform your view of the Constitution. 51 Imperfect Solutions, States and the Making of American Constitutional Law, among many other important works. And he clerked both for Justice Powell and for Justice Scalia. And Judge Diane Wood is Chief Judge of the U.S. Court of Appeals for the Seventh Circuit. She has transformed the law with her judicial opinions, which are regarded as definitive on so many of the areas she writes and teaches in at the University of Chicago Law School, including antitrust, federal civil procedure, and international trade and business. And she clerked for Justice Harry Blackmun. Judge Sutton, I'll begin with you. You clerked for both Justice Powell and for Justice Scalia, who took different approaches to the Constitution. How do those two clerkships influence your view of being a judge?
Yeah, well, thanks for not mentioning this little thing. I was thinking no one would notice it, but everybody has. So this is the problem with being able to throw a 98-mile-an-hour fastball. Eventually, the problem with that story is twofold. I'm a righty, and if I could throw a 98-mile-an-hour fastball and I was a lefty, I would not have been a lawyer, and I certainly would not have been a Supreme Court clerk. There are way better careers than that. So it was such a blessing. Well, first of all, Jeff, thank you for doing this, and thank you for all your leadership with the National Constitution Center. The country's really lucky, and you've been amazing for that, and it's really helpful to all of us who care about the court, the constitutions, all 51 of them, but thank you. So yeah, I really was lucky in so many ways to have these clerkships. I'd gone to Ohio State. It was not a traditional path from Ohio State, so that was very lucky to start, but the greatest thing for me that year was working for two people that spoke entirely different languages about the Constitution. Justice Powell came to the court as a practitioner. He was a pragmatic. In many ways, he was very much a forerunner of Justice Kennedy, cared a lot about civility, case by case, embraced totality of the circumstances tests, incremental judging. And Justice Scalia was very much not that. You know, his key articles, a rule of law is a law of rules, which kind of gives it away. And it was so remarkable that year to be dealing with two people that it was like my mother and father. I love them both, but they disagree on everything. How does this work? Well, my mother and father, they got divorced, actually, so it is really quite parallel. But I really adored them both, and it was just so interesting to be thinking about cases and wondering, wow, I think Justice Powell would really have thought about this differently. And I'd be in conferences with Justice Scalia, and he'd be critiquing a Powell opinion that had this balancing test that was utterly unpredictable. So as a young lawyer, that was just so striking to me, to see two people that I just really adored, admired at so many levels, speaking utterly different languages. And so the great gift for me was to come out of this experience, certainly not knowing how to speak those languages fluently, but being very interested in mastering how to speak them fluently. And that really influenced me, first as an advocate, and then as a judge, which is, so I've been influenced a lot of different ways by all of them, or both of them, but I really do, in my opinions, try to speak all languages and try to write an opinion that is not just going to be convincing to somebody who believes in textualism or originalism, which happens to be my preference, but can see it a lot of different ways. And that's been really healthy. I suppose it makes me a little ambiguous sometimes as to what I'm really thinking. But, as a Court of Appeals judge, in many ways, that is the best training, because half the opinions, the constitutional opinions at the court, are more originalist in nature, and half of them aren't. So I actually think it's really good training for a Court of Appeals judge, because we're supposed to be able to honor both sets.
That's so striking that you took from Justices Powell and Scalia an ability to speak all of the constitutional methodologies. And I have here your opinion in the marriage equality case that became Obergefell, where you do exactly that. You run through all of the constitutional methodologies and explain why the result that you chose you felt was compelled by all of them. How interesting to trace it.
Perhaps explains why it was reversed. But not for lack of speaking all the languages.
No, you did.
I spoke all the languages.
You did.
Just not one of them well enough.
Not at all. Even Homer nodded. Judge Wood, what did you learn about the art of judging for clerking from the famously detail-oriented and particular Justice Harry Blackmun?
I learned a great deal, of course, both from clerking for Justice Blackmun and also from seeing the different approaches around the court. Now, I will say that at the time I clerked at the Supreme Court, the so-called originalism, plain meaning approach had not yet carried the day with as many people. It wasn't really until Justice Scalia came or so when that became more popular. My observation of Justice Blackmun actually goes all the way back to the fact that he came to the law as a mathematics major. Remember, his undergraduate degree from Harvard was in math. He was a summa cum laude awardee of that degree. And I think that it carried over into his approach to law, and it's something that I've thought a lot about. He was very comfortable with the scientific method. He was very comfortable with working from the ground up, from the facts up, and coming up with a rule of law that was solidly based in the facts. He did not like a top-down, I've already figured out what all the categories are, and I'm going to shove this case into one, or I'm going to shove it into the other. Now, at the Supreme Court, there is some virtue in a fact-based approach, but because it's the final court, you lose some certainty when you don't have a clear theoretical construct that your opinion is going to fit into, because you're speaking for the entire country. And I actually think of that, it's not the whole country, but it's 3 states. When I'm writing opinions, you owe it to everyone. You owe it to the parties, you owe it to the people who live in your circuit, you owe it to the business community, you owe it to individuals to be clear. This is why this person won, this is why this person lost, and we're going to make it possible for you to follow these precepts in the future. The famous Justice Powell balancing tests, to which Jeff has referred, are actually not my favorite either. I find them impossible to do anything with.
Be nice to him.
I'm being nice to him. When they're weighted, then you can begin to work with them. But if you just say, here are the following 10 factors, balance them, as a lower court judge looking at a Supreme Court instruction, I can maybe chat about all 10 of them, but you're not really going to know why one of them was important and the other should prevail over the other. So working for the court at the time I did, I thought a lot about the importance of theoretical constructs, the importance of the underlying facts, and I felt less critical of Justice Blackmun for his reliance on those facts because, face it, there are areas, especially in constitutional law, I would say, where it behooves the court
to move slowly. It behooves the court to move incrementally to make sure that the path they're charting for themselves is in fact the right path, and they haven't overlooked some major qualification that we just didn't know about. You thought it was all clear at the time of the opinion, but it turns out not to be so clear.
I wrote many pieces as a young, overconfident journalist that have proved to be wrong, but one about Justice Blackmun was called The Emotional Jurisprudence of Harry Blackmun, and talked about his famous opinion in the Descheny case, poor Joshua. I have to tell that after I wrote that, a clerk that same term said he had just been working on a case called Schmuck versus United States. I was glad that it wasn't poor Schmuck.
Poor Schmuck.
Yes, absolutely. but you're saying that really was wrong, that Justice Blackmun was not primarily a top-down emotionalist, but was driven from bottom up from the facts.
That was what I saw.
And that influenced you. Jeff, you've heard the clerks on the previous panel give particular examples of either personal encounters with the justices or especially illuminating moments that really changed their philosophy. You emerged from your clerkship preferring Justice Scalia's textualism and originalism to balancing, although you combine them both. But can you share with us a moment or two with either of those justices that helped push you in that direction?
Yeah, so I mean, it's, you know, I really, it was so much fun to listen to this last panel and just try to think a little more than I usually do about the roots of where I am and my problems. I think I took half from both of them. So Justice Powell was a good Virginian, and he believed in federalism. I mean, you know, that was really a key theme of his jurisprudence, and that became a key theme of my advocacy. I'm sure it was a reason I was excited about working for the state of Ohio as the solicitor, and did a bunch of those Section 5 Commerce Clause cases. That's really been the interest I've had in terms of writing. It is true. And that's not Justice Scalia, by the way. Justice Scalia is definitely a creature of the Beltway by the time he was on the court. And so I don't think he had the same sympathies. So in that sense, I rejected Scalia a little bit and followed Powell. But it is true on methods of interpretation. I'm very much more of a textualist and originalist. And that, you know, that grows out a little bit of the influence of Scalia for sure. What it really grows out of is something I think all of us would share from this day. You come to love the court as an institution. It's just really hard to work there and not leave it saying, I care so much about this place. I love every feature of it. I love every employee. I'd come back to argue. They'd all remember your name. And you always felt like they were rooting for you, like they were rooting for every advocate. They couldn't. Of course, they were both, one's going to lose. But I just love the court as an institution. And I think one reason I've really embraced textualism and originalism, perhaps people will disagree with me, but I do think it's more likely to protect the court as an institution and help us get away from the politicizing of it. So that has influenced me. You know, in terms of experiences with them, I mean, there are just so many, but, you know, one with Justice Powell, which of course has nothing to do with law, although in a way maybe it does eventually. He was 85 at the time. You know, if you're a retired Supreme Court justice, a little warning to you if you're going that route, people don't invite you to lunch anymore. So he was stuck having lunch with his law clerk. He had one law clerk, retired justices get just one, and we'd have lunch once or twice a week. At the Monocle, it's this great Washington watering hole. He treated me every time. Every day, same thing. He'd get a cheeseburger. He'd eat like an eighth of it. He'd get a glass of Kendall Jackson Chardonnay. He would drink all of that, but just one. And then he'd treat me to whatever. But here's the most interesting part of it. You would have thought during that year we would have spent all this time talking about Bakke and his great cases and the court and interpretation. I had to pull him kicking and screaming to those topics. He wanted to talk about winning the war, Richmond, the Richmond School Board, Hunt and Williams, and above all, his family. It was my first experience talking to someone I cared about and hearing them thinking about challenges with raising children and grandchildren. It was so striking to me to see an all-powerful, retired justice of the U.S. Supreme Court talking about, well, gosh, I'm really sad my child's getting a divorce or something. And he was stuck with me as the person to talk to about it. And that was really powerful, kind of putting it all in perspective. And, you know, then our first child was born the night of the State of the Union that January. Justice Scalia had to stay back then, a lot of them went to those things. And so the justice said, Jeff, do you want to come? You want to go for a run? Well, I shouldn't have done that. My wife was in labor. It's a pretty selfish thing to do, but she approved it. So we go on this run. He knows we're about to have our first child, and he spends the whole run saying, Jeff, raising kids is so important, and, you really got to make sure you have balance in your life. And I didn't have a lot of self-esteem then, so I thought he was just saying, Jeff, you're not going to be a good lawyer. At least you can try to be a good father. I don't think that's what he meant. I really think he was making just a good balance point. And so there's a lot of, we'll come back to other ways of influencing, but I don't want to lose track of the personal side of it, which was the theme of some of the earlier panels. I mean, you really adore someone, you so respect them, you so want to be like them, and then you hear them talking about things that have nothing to do with interpreting constitutions, statutes, or courts. And so it resonates perhaps a little more than it would be if it was just your buddy or your uncle.
Thanks for that. Judge Wood, some personal encounters with Justice Blackmun where you got some life lessons that influenced you.
Wow, life lessons. I mean, he was very generous with his time with us, and he had certain things. People think of Justice Blackmun as we heard in an earlier panel, as this monster who required 35-page bench memos and marking up all the cert memos and writing. And I will say, I'm a really fast writer, and I'm an amazing typist because this was a time before the court had computers. It's that many years ago, so it was an actual typewriter, and the cost of an error was too high. So you had to be good. But it was a very spontaneous thing. He would just walk through our office where all four of us sat, myself and my three co-clerks. And he'd suddenly say, what do you think about that opinion that he used initials for everybody, BRW, Byron White, circulated, or LFP, or, et cetera, JPS. And you had to be like on your toes that second and you had no way of knowing which one was going to suddenly cross his mind. And he would do the same thing, by the way, at his famous breakfasts. I was living in a little dumpy basement apartment on Capitol Hill the year I worked at the court. And I usually showed up on the dot of when breakfast began with my hair dripping wet because it was lucky I had actually managed to get out of the shower and get over there. But you had to sit there and listen to a fair amount of chatter about baseball, which he did love. Everybody may remember, or maybe the students won't, but the famous footnote in Flood versus Kuhn was not forced on his part. He in fact loved baseball that much. I'm an okay baseball person, but I learned to maintain my part of the conversation.
Did you watch games and start following baseball so you could keep up?
I read about it. I couldn't quite.
Did you feign enthusiasm?
I feigned enthusiasm, okay. Yes. You had to do that at least. But then in the middle of, what somebody did in the seventh inning, there'd be, what did you think of this opinion? And if you thought that he might want to do something different based on what he had said in the past about whatever that issue was, again, you just had to be on the spot. I'm not actually a morning person at all, so this was maybe one of the greater challenges of the clerkship. But that was the way he just liked to do it. And the other thing that really opened a window into not just Justice Blackmun, but the entire court, was his famous conferences with us after the conference. So the justices would sit down to discuss whichever the cases were, the Monday cases on Wednesday or the Tuesday-Wednesday cases on Friday. And then we'd all go into his chambers, and he would sit down justice by justice and give us I think it was practically a transcript, exactly what those people had said about every case that the court had heard argument in. And Justice X said this, and Justice Y said that, and he'd do himself in order, and what an insight. I mean, it was just an amazing insight into the way the justices were working their way through the different viewpoints, and sometimes it was outcome determinative, of course. many times it was more, what's the right reason for this? You know, what is this a statutory case or a constitutional case? Is this a case that in which we need to say something grand about the meaning of due process, or is it actually something much more granular, or at least if you get a majority of the court on a more narrow ruling, is that something you should go with or not? So we had amazing conversations with him about that, and it certainly taught me a tremendous amount, both about the way the justices themselves went about their decision-making, and also, of course, in later years, how I've done it.
Did that uniquely granular view give you more or less respect for the way the court functioned as a nonpartisan institution?
It gave me tremendous respect for the way the court functioned, and I'll share, if we now fast forward to the time that I've been on the Seventh Circuit, we happen to have a case, every year maybe we hear maybe 4 cases in bank, maybe 5, it's not very many. But we had heard this particular case in bank, and our practice is to go around the room and everybody talks first, and you're not supposed to vote, even though you can kind of tell how somebody's going to vote, but you're supposed to talk, and then you just kind of crisscross with questions, and then you go around the room and vote. And as we started the voting in this case, it was before I was chief judge, I thought, I'm really sorry the public can't see this. I am so proud of this court. You know, people are grappling with these issues. They're hard issues. They're issues on which people at a personal level feel passionately, but everyone's being respectful. Everyone is thinking of the way our law ought to treat those questions, not just the way your personal preference should. We're all acutely aware, you know, that whatever it is, the 23 million people in the Seventh Circuit didn't elect me to do anything. They trust me to follow the law. And I saw that in Justice Blackmun's accounts of the way the justices were handling their discussions, and we certainly strive to do the same.
Jeff, do you feel the same way about the Sixth Circuit as you do about the Supreme Court? The Sixth Circuit, like other circuits, has had times of great division and other times of more collegiality. And what are the differences and similarities among the Sixth Circuit and the Supreme Court that might affect the way it functions as an institution?
Well, so most of our work is done in 3-judge panels, so it's intense, but it's just 2 other people, and that actually makes it a lot easier. I can't imagine having all my work with 9 people. That's hard to imagine. I'm not a big fan of the in-bank process. I'm a very hard vote on that because I don't enjoy decision-making in a group of 16. Now, I will say it is fun to hear a bunch of us talk about something really difficult, but it's just very hard. You know, you don't have 7 hours, which is probably what it would take to really figure out what everyone thinks and account for every perspective. But you know, the thing I was going to say about something you see about developing the right answer, what the reasoning was, and it sounds like Justice Scalia was like Justice Blackmun in this respect. After every argument day, he would pull the clerks in together and we would actually debate the case. So we have an adversarial process as the case is being presented in the courtroom, and then afterwards we'd have a very adversarial process back in his chambers. He didn't want to talk to the clerks too much before the argument. In fact, he asked for, this was a contrast with Justice Blackmun, he'd asked for a bench memo that was no more than two pages. We're like, well, I hope single-spaced and no margins, right? So he didn't want a lot of wind-up. He was like, I've read this. We're going to talk after. So he might talk a little before, but not too much. But then after the argument, the clerk whose case it was would present the case to the group, and everyone was an equal in that debate. I mean, that was a really striking thing to learn after a couple of these conferences, that he didn't respect you if you didn't push back. He would just ignore you. He didn't want to hear that he was right. He just didn't interest him. What interested him is why he might be wrong or why he might need to think about it slightly differently. And those were just unbelievable debates and conferences. And, you know, so I find that's influenced me more is how I work with my clerks than perhaps it has how I work with my colleagues. You know, we don't debate that much. I mean, we assign, unlike the Seventh Circuit, we pre-assign opinions or responsibility for opinions. Obviously, if the pre-assigned author ends up in dissent, they don't write a majority. But that means we have a lot of communication in most cases before argument, which means there's less room to talk. I mean, it's not unhealthy. The California Supreme Court does this. The Ninth Circuit does it. You can see competing arguments on both sides. This was a practice that was there before I got there. But what ends up happening is we really put a premium on those, maybe a bench memo circulated, maybe a draft opinion circulated. There'll be memos back and forth about what's been done. And by the time of argument, most people really have a sense not only of what they think, but what their colleagues think. And, so it means we usually have shorter conferences, which, again, I can see both sides of it. It's probably not the approach I would have developed on my own, but on the other hand, I've come to see some virtues of it. It gets opinions out more quickly. It means arguments unbelievable because everybody's really prepared and really asks questions that really matter. So that, of course, is not what happens at the U.S. Supreme Court. They do not circulate. They do not pre-assign opinions. They do not circulate bench memos to other chambers, much less opinions. So that's quite a striking difference.
Back to constitutional philosophy, both of you are unique among appellate judges and among Supreme Court justices in having written powerful and deep accounts of your own constitutional philosophies. And Judge Wood, you gave the Madison Lecture at NYU, and yours was called Our 18th Century Constitution in the 21st Century World. You gave an account of why the Constitution should evolve in light of social and technological change, and you defend that approach against an originalist approach. To what degree did your dynamic approach, how was it influenced by Justice Blackmun? And I think it's much more systematic than Justice Blackmun was, so why don't you describe it and then contrast it with his?
Right, so that's the title, and I was influenced to write the thing by the fact that there are certainly some parts of the Constitution. Everyone thinks of the Eighth Amendment, where the Supreme Court itself has said, and it has never overruled, the notion that our standards of what cruel and unusual punishment means have evolved with the times. And if they were hanging horse thieves in 1791, we probably don't want to be hanging horse thieves today. And that made a great deal of sense to me. And I think over the year that I worked for Justice Blackmun and observed the work of the court, I saw so many applications of the broad-ranging language of the Constitution that seemed to me really just contemporary applications of a broad principle. And my own thinking is probably more contextual at this point. I think that the people who wrote the Constitution were very bright people. And I think when they wanted to be very specific, they were very specific. So they said the president has to be 35 years old. I'm not going to go into some big thing about whether 35 counts the 9 months of gestation or not. I'm going to go with 35 as we all understand that term to be. The titles of nobility clause hasn't really occasioned much litigation as far as I'm aware. So I think when they wanted to be very particular, they could. When they wanted, if you will, to state a standard, equal protection, that comes, of course, later, but due process is in the Fifth Amendment and obviously the Eighth Amendment. When they wanted a standard, they gave a standard, and I think they fully expected that this would change. Frankly, if you want to take a very originalist approach to the 14th Amendment, you would say women weren't included. And the Supreme Court crossed that bridge as well. It took them a little while to do it, but they seem to be fairly securely there at this point, and I'm glad they are, and I think that's the right way to interpret the Constitution. It's a very broad principle in there. So I think that some of the most litigated parts of the Constitution are, in fact, the parts that are just inherently broad and sweeping: due process, equal protection, cruel and unusual punishment, et cetera. And my personal view is that it would be unfaithful to the Constitution itself not to give them that kind of flexible meaning. The other thing I'll say is that part of that lecture, I don't know how well it came out, but part of that lecture was a plea for consistency, because if you're going to say, for example, that the president's power over foreign relations includes the list of things that we would now put in that list, you can search long and hard in Article 2, and you're not going to find those things set forth. You're not going to find, the president's ability to wage war without Congress's permission for some period of time that now is sitting there in the War Powers Act. So it seemed to me if you really wanted to be a strict constructionist, a lot of things that you think about Article 2 would have to go out the window. And I'm not advocating that they do go out the window. I mean, it's actually quite consistent with my sense of the interaction among the branches of government. Congress and the president, have their own constitutional responsibilities, and that's what they need to carry out. And I am not one, just to conclude this, who thinks that it's necessary to throw out the administrative state just because that wasn't originally set forth in the Constitution. So I really think the reason our Constitution has worked is that we have had a flexible and evolving approach to it.
Many thanks for that. Judge Sutton, you've set out your distinctive and important philosophy in many places, your state constitutions book, your opinions,